Warren Township Board of Adjustment for May 18th, 2026. The legal notice required by the, according to the Open Public Meetings Act, has been satisfied, and a statement certifying same will be executed. Please join me in the Pledge of Allegiance.
Allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
The first item is the consideration for approval of the minutes of the March 5th, 2026 reorganization and special meeting.
Don't we have to do a roll call?
Oh, we're going to do roll call first.
Mr. Goldberg.
Here.
Mr. Trachtenberg.
Here.
Mr. Williams.
Here.
Mr. Schuster.
Here.
Mr. Benoit.
Here.
Mr. Kramer.
Here.
Mr. Woodford.
Here.
Ms. Simmons.
Here.
Mr. Evangel. And then for the board staff, we have our board attorney, Mr. Uller.
Here.
Our board engineer, Joseph Voigt.
Here.
And our board planner, Kay Keller. Here. And I am Ryan Kerpa, the board secretary.
Okay. So now, first item is consideration for approval of the minutes for the March 5th, 2026 reorganization and special meeting. Everybody reviewed that. Any comments, questions? If not, I'll entertain a motion.
I'll make a motion.
Second.
Thank you. All in favor?
Aye.
All opposed? Motion carried. Next is a resolution for the application BA 28-25. Mr. Olaf.
Thank you, Mr. Chairman. This is a memorializing resolution with respect to the application filed by Todd McNamee for property at 46 Burnham Road, who applied to the board for permission to modify an existing non-conforming dwelling by constructing an addition, which required variance relief for side yard setback of 5.8 feet where 10 feet is required, combined side yard setback of 4.8 feet where a minimum of 20 feet is required, impervious coverage of 56.2%, which was both already existing and it would be proposed, where a maximum of 55% is permitted, and to expand the non-conforming structure. For the reasons set forth in the resolution, that application was conditionally granted with our standard conditions.
Board members, any comments, questions? If not, I'll entertain a motion.
So moved, Mr. Chair.
Second.
Thank you. Roll call.
Mr. Goldberg.
Yes.
Mr. Trachtenberg.
Yes.
Mr. Williams.
Yes.
Mr. Schuster.
Yes.
Mr. Benoit.
Yes.
Mr. Kramer.
Yes.
And Mr. Woodford.
No, Ms. Simmons.
And Ms. Simmons.
Yes.
Okay. Resolution is approved. Next we go to the public hearing. There's two on the, thank you. There's two on the agenda tonight. We're going to skip ahead to BA-02-26 because it looks like a relatively short application. So please introduce the application.
This is application BA 0226, block 9606, lot 3, street address 4 Flintlock Run, in the RA 15 zone for a section C variance. The applicant proposes construction of a 2-story addition on the rear of the principal structure, a new patio and a new deck, where the variance request is for pre-existing non-conforming right side yard of 16.32 feet with a proposed 16.28 feet, and there's 20 feet required.
Okay. So we have you, wait till everybody's here.
Okay. Can we have everyone's name for the record, please?
Yeah, Matthew JZL.
Would you both please stand and raise your right hands, please? Do you solemnly swear that and our professionals as well, do you solemnly swear that the testimony you will give to this board will be the truth, the whole truth, and nothing but the truth, so help you God? And again, for the record, everyone for the record, please, your name.
Yeah, Matthew JZL. Robert Forbes.
Okay, Mr. Forbes, can you give us the benefit of your background?
Graduated from New Jersey Institute of Technology in 2007, getting licensed in the state of New Jersey in 2014. I've been practicing locally ever since. My office is in Shore Hills. I've been before multiple boards in the area. This board not recently, but probably 5 years ago. Some of the other boards, Summit, Chatham Borough, Chatham Township.
And your license is intact?
Yes.
Thank you. Accept you as a professional and an expert in the area of architecture. Okay. Who's going to proceed first?
Yeah, so, my name's Matt. My wife and I just moved into town, coming on 4 years, and we bought a house that we loved in the Cromwell neighborhood. And we love all of our neighbors and have decided that it's a place that we want to stay, and wanted to expand on the back of the house just so we have more room, since we've got a 1-year-old daughter now, and plan on having more. So we wanted to have more room and update the kitchen so that we've got a nice area to hang around, since it hasn't been updated since it was built.
So you've reviewed the plans and this is what you want to do?
I have, yes.
Okay. Board members, any questions? Professionals, any questions? Members of the public, any questions of this individual? Seeing none, hearing none, close the public portion. You may proceed.
All right, so Matt and his wife Kayleen came to me, like he said, looking to just do a marginal expansion in the rear yard, just to make the really the first floor a little bit more modern to today's standards, give them better access to the rear yard. So the address here is 4 Flintlock Run. It's lot 3, block 960. It's in the RA15 zone, where we are required to have a 15,000 square foot lot. We're just over that minimum at 15,028. It's a bi-level home, one of those mid-20th century styles, built very efficient floor plans, not a lot of extra space within them to move stuff around. So what we're doing, and I can kind of, if I can use that microphone, I guess. That's
Sure.
the microphone.
Is it on?
You might have to turn it on the bottom.
Hello?
You have to hold it for a couple seconds.
Light up.
The light's up, you're good.
Good? Okay. So,
So, Mr. Forbes, what you have on your easel, is that the plan that we have?
yes, it
And
is.
it hasn't been modified or rendered?
Not at all.
Okay, so then I don't need to mark it. Go ahead.
So if I'm looking at sheet BOA 1 in your packet, and I look at the proposed survey, Flintlock Run is here. We're looking to do a 10-foot addition on the right side here, where in your zone RA15, we are required to have a 20-foot side yard setback. The existing building is set back at 16.32. It's a little bit skewed in the front at 16.4, so when we do that 10-foot addition, we actually end up with 16.28. So this existing non-conforming condition gets ever so slightly worse, but we're staying in plane for those 10 feet. We then have a small deck down to a patio. We have a big setback on the left side, so we are actually in compliance with the combined side yard setback. So really what the hardship here is the siting of the existing building is just slid a little bit too far to the right. If we could pick the building up and just move it slightly left, we would be in compliance. And I think that's important to note because the overall length of the building is compatible with the zoning. It's not like the building is extra long. Everything else is in compliance. The building, the site's not saturated. Building coverage is required, or maximum is 20%. Existing is just under 10%, and we're proposing 11.55. Lot coverage, you're allowed to be up to 45%. Existing is at 23.33. We're proposed at 28.79. Again, nowhere near saturation of the site. Building height is allowed to be up to 35 feet. One of the benefits of this neighborhood is that a lot of the older buildings sit lower at about 26 feet. So this building really is very much compatible with the neighborhood and kind of understated. One of the benefits of not kind of starting over and building a big new house there, that wouldn't be necessarily compatible. I'm going to flip the sheet, just walk you through the floor plans real quickly. So this is the lower level of the bi-level, right? So if you would come in the front door and you would go down half a flight, there's a bedroom down there and a bathroom. We're renovating the bathroom, and there's that 10-foot addition off the back, kind of creating a family room down there for them, with access to the below the deck and the patio. There's that setback. There's that required 20 feet. So if I could just slide the building, I would be in conformance. Here's the first floor. So you come up from the bi-level, you come in, you got a little living room. There's that original kitchen that we see a lot, in a very small eating area. We're just pushing back 10 feet, creating an open floor plan. The deck we pushed back off the plane, and we just have the steps coming down. So that gives some relief along that right side setback. There's the front elevation. Really nothing is visible from the street. It's all in the back. There's the left side elevation. You can see the garage doors existing, the deck in the foreground. The rear elevation, this is this addition right here that we're proposing. Again, not going above the existing building height, staying actually a little bit underneath it. Here is the continuation of that existing non-conforming side for that 10 feet. And that's really it. And then today, before I came here, I put an exhibit together of pictures I took this morning of the site that I'd like to, if possible, mark in.
Sure. Would you just mark that A1, please, and put today's date on it?
Sure.
Is it one sheet?
That's one sheet, yep, with photos and a satellite view that I took today. So here's just a photo of the front of the house. Again, nothing that we're doing is going to be visible from there. Here's the right side. I thought this was important because you can see the neighboring house that would be most affected. That is their driveway. So their house is quite pushed off of the property line on this side. There's actually about 35 feet between the two buildings. And the neighbor kind of goes down this driveway and then turns in. So this is really the utility side of their house that we're kind of closest to. Here is in the back where there's that existing gravel patio. This is where we're going to be doing that expansion. Here you can see Matt and his wife actually started to plant some skip laurels to kind of create some buffer that'll hopefully grow in the next few years. Here's a satellite view showing this. Right, so I'm just trying to show that there's really no negative impact to the neighbor. There's plenty of light and air between the houses. And everything else is really in compliance. So for us, we feel like there's the hardship of the existing siting of the building. And we also really feel like the positives of modernizing this house, maintaining the existing house that's compatible with the neighborhood really outweigh any of the negatives here.
Thank you. Board members, any questions? No. The only question I can see, I see that fence on the, that's on the plans on the survey. Part of it's in one lot and part of it's in the other lot. What's the deal with that? Has there ever been any?
The fence on the other side here?
Yeah.
So that was in before we had moved in, and my neighbor and I both agreed that we didn't want it there and didn't need it there, and so I gave him permission to take it down.
Okay. So has it been taken down?
Yes.
Oh, okay. All right. Thank you. Board professionals, any questions? Any member of the public with questions of either witness? Seeing none, hearing none, close the public portion. Board members, any opinion on this application?
Pretty straightforward. The change in encroaching 4/100ths of an inch in addition to the prior encroachment.
So basically,
It's de minimis.
four.
Pick that up from you guys.
Yes. No one will notice. So could I
I make
Have
a
a
motion
motion.
that we approve this application as proposed.
Second.
thank you. Roll call?
Mr. Goldberg,
Yes.
Mr. Trachtenberg,
Yes.
Mr. Williams, Mr. Schuster,
Yes.
Mr. Benoit,
Yes.
Mr. Kramer,
Yes.
Mr. Woodford.
Yes.
Motion carries.
Thank you.
I'll have a resolution for you at the next meeting. Thank you very much.
Thirty a millimeter. It's a millimeter.
Yes.
tenth of a foot.
I think it was 4 inches. No, 4/100 of an inch. It's different.
Okay.
Yeah. What it was, what it is now.
Next, we go to BA-04-25, 383 South Street LLC.
Right. 4/100. Which is a millimeter. Do with it. A little closer than the
They're not in here.
1 millimeter.
They didn't expect.
Means
Right.
definition of the millimeter.
3.2 to 2.8.
Yeah.
Just bring it up here.
Thank you.
Thanks.
Thank you.
Okay. Those guys in the back?
Yeah, I think George just went to it.
Oh, here they come.
Just under a half inch.
Different?
Yeah.
4/100s.
Yeah.
Of a foot. Oh, yeah, the 400 inches.
0.48
400 of a foot.
Yeah.
So half
Sometimes
an
you
inch.
look at those and you think it's feet and
So
inches.
it's, so it's like under half an inch.
Exactly. 0.48 inches.
I'm gonna change it those now.
I'm thinking about it.
It's diminished.
Half an inch there, leave it out.
Take a break first.
No. Either way, they would have the other.
I'm good.
Are we good?
You ready?
Yes, sir.
All right, Mr. Kelly.
Good evening, Mr. Chairman, members of the board. Nice to see everybody this evening. For the record, Larry Cali on behalf of the applicant, 383 South Street LLC. Mr. Chair, I'd like to briefly frame where I think we left off, and then I'll turn it over to the board, because I think it's back essentially in the board's hands at this point as we continue the process. The last public hearing, we concluded redirect of a few witnesses and direct of our final witness, the new witness, our acoustic engineer, along with redirect of civil engineering and planning as well. At that point, the objector concluded their case in chief. We concluded ours. There was no more cross-examination open, but the hour was getting late. And prior to either applicant or objector providing any summation statements, and then we had a dialogue with the board as to what prospective conditions might be if this board had a motion to vote affirmatively on the application, we said we'll be back next month.
Right.
And that's where we essentially left it. So at this point, we are not continuing with any witness testimony. At this point, we will let our objector say whatever he would like to sum up when it's the board's pleasure. I know we have public comments still at a certain point. And then perhaps we can dialogue as to the prospective conditions, which is a long list that both Rich and I have been keeping for many, many months on this project. And then I think we're at sort of the natural conclusion at that point for the board to deliberate this evening and hopefully put the matter to a vote this evening is our goal.
Okay, one of the things I wanted to address, received this letter from Mr. Rosenbach. It's basically a letter brief outlining whether this is a major, requires the where there's a major application,
Major development.
major development. So why don't we hear from Mr. Rosenbach about why he thinks it is, and then we'll hear from you as to why it shouldn't be, and then we're going to hear from Mr. Hoyt as to whether it's what his position is on this.
Certainly, and we're going to rely on the testimony of the prior sworn witnesses as well, which is Mr. Stewart and Mr. McClellan.
Right.
Testified that it's not triggered, so my proffer can only bolster that so much.
Right.
Council, so I think we'll be a pretty quick date in that regard from our
Okay,
side of the table.
but
Mr.
let's
Chairman.
get that moving. Why does he sit in the middle?
Thank you, Mr. Chair. I sent this letter more than 2 weeks ago because I thought that it was, to begin with, very complicated, and I wanted to make sure that the board had the opportunity to focus on it. And also because it was very important to me in the sense that it is not testimonial, it is a purely legal argument. Mr. Chair, you already described it as a brief, and it is a brief. And it is purely legal, and it relies on the relevant case law and on the New Jersey Administrative Code. And what it is doing, of course, is challenging the testimony that was given to the board on rebuttal by, I believe, was it Mr. Mueller, was that his name, who was talking about a penetrometer and how soil, depending on how compact it is, can be considered as an impervious surface. And what I was doing, and what I did do in this letter, which I hope everybody has read or has a chance to read, is to say, it's just not right, that under the regulations, the quality of the soil, and whether it at one point in its life has been compacted, at one point if it hasn't been, it has nothing to do with whether this is a major development and whether, therefore, this board has to require that the applicant do more. So the letter itself has, I guess, 4 pages. And what I do is, one thing I note, by the way, is at the top of page 2, I cite a reported appellate division case called Safe Hamilton Open Space, which means it's binding on this board as every other board in the state. And it says that it is the responsibility of this board, not the DEP and not someone else, it's the responsibility of this board to determine on the record whether the application complies with stormwater management rules. And the board may not defer that determination to other agencies or condition approval on future compliance. So to be real clear about that, a board shouldn't say, we're approving this, provided that somewhere down the road you get DEP approval.
Yeah, so let me just cut in where you're at, Phil. Okay, so I agree with what you just said. I think that the Safe Hamilton case really just says what the regulation says, right? And the regulation says that whether it's a major development or not gets determined at this level.
Yes.
Right. And when we get to it, our engineer, we're going to ask him for his thoughts on.
I understand that.
Position.
And by the way, one of the other things I say, and I guess I'll get to it. I'll try to go in order. I don't want to read the letter, but I do at that point go through the definitions, because there are a series of definitions in the New Jersey Administrative Code, and just like the appellate court, the New Jersey Administrative Code controls this board. We can't evade it. It's statewide law, and so the New Jersey Administrative Code defines. First of all, it defines what a major development is, and it talks about something called regulated impervious surface. And regulated impervious surface is defined. And at the top of page 3 of my letter, there's a somewhat lengthy definition of regulated impervious coverage. It's more than 10 lines long. I'm not going to read it. And that definition itself relies on the term impervious surface. So you get from regulated impervious surface to impervious surface, and that's defined. And that's a very short definition. That is a surface that has been covered, I will repeat the word covered, a surface that has been covered with a layer of material so that it is highly resistant to infiltration by water. Now, we all know what it means to cover something. It means there's something somewhere and you put something on top of it. So that is completely antithetical to saying, oh, gee, if some dirt happens to be more compacted, it becomes an impervious surface, because it isn't. There's no cover over it. So under these regulations, unless there's a cover, and that cover could be asphalt, it might be gravel, it could be a building, but it's not just dirt that's lying there and has been lying there for decades. So for that reason, all this testimony, and again, I'm saying this as a matter of law. I'm not an engineer, and I'm not testifying as an engineer, but I'm a lawyer. And I'm saying that as a matter of law, all the testimony you heard about the penetrometer, it's irrelevant. It has nothing to do with whether something is an impervious surface. Now, I also note that it's up to the board, clear law. It's up to the board to accept or reject expert testimony. You can reject my experts, you can accept them. You can accept their experts, you can reject them. But a court cannot rely on expert testimony that flatly contradicts the pertinent legal authority. You can't just make stuff up that's contrary to law. So I say that in my letter. And finally, I say one more thing. And it's not an attack on the board, and it's not an attack on the engineer, for sure. But it's just a statement of the law, which is ultimately, it's the courts that determine and interpret regulations and even town ordinances. Everyone on this board can have an opinion on what a town ordinance means. Mr. Oler can have an opinion. The engineer can have an opinion. The planner can have an opinion. I can have an opinion. Mr. Cali can have an opinion. But our opinions aren't that important. What's important is what a court decides. And there are well-known rules about what courts do to determine what things mean. And one of the rules is they don't rewrite things that are pretty plainly written. And when something is plainly written and says you need a cover, it's not up to anyone else in this room to say, well, it says that, but we're going to interpret it differently. And that is my analysis that I wanted to present to the board. And again, I appreciate the chairman allowing me the opportunity to address it. You could ask me questions, but all I can do is pretty much parrot what I already have. That's a question. My name is Philip Rosenbach, Rosenbach.
Board members, any questions of Mr. Rosenbach about his arguments here? Mr. Oler, any questions?
None.
Okay. Mr. Cali?
Very limited. I mean, Mr. Chairman, members, we've all been here. I'm on that side of the table often, I'm on this side of the table more often. Chapter 1 of an objective manifesto is delay, delay, delay. That's the game. We're not too surprised there was an 11th hour submission by Mr. Rosenbach. I understand that the intent might have been meritorious, but it's nothing more than an opinion opining as to engineering criteria and scrutinizing engineering review. We disagree with it. The board has heard significant engineering testimony from the applicant's 2 engineering witnesses over the course of the past year and more on this application, following completeness determinations, following several tech meetings with Mr. Vucha's office, discussions between Mr. Stewart's office and Mr. Vucha's office leading up to this major development minor inquiry that we've got here today, right up until the April public hearing when Mr. McClellan was back here testifying. That door is closed. I understand Mr. Rosenbach's argument. He's probably going to have 15 more if he decides he wants to challenge a board approval, should this board approve the application. The issue is closed. This is ripe for a vote this evening. All testimony has concluded. He continues to opine on an engineering disagreement. I'm comfortable with the sworn testimony of our expert witnesses who swore on their license that this, in fact, is not a major development. And even more than that, I'm happy that the board has the cover you do with your own engineer to give you his guidance on behalf of the board as well, essentially sitting in a mediator capacity of which engineer may have been right or wrong. So at this point, Mr. Chairman, we continue to rest our case in chief, notwithstanding the letter submitted by Mr. Rosenbach, and we look forward to moving this forward towards prospective board deliberation this evening.
Well, you've reviewed what he argues as to the definitions. Do you have any counter to that argument?
Well, he just restated the definitions. I mean, I will say that Title VII, it defines impervious quite broadly. Any surface limiting infiltration. That was part of Mr. McClellan's testimony during the last public hearing as well. So an interpretation as to whether or not that methodology was implied in line with that interpretation, it's wholly subjective. He can have any opinion he wants on it at that point. You've heard testimony from the engineer, as did Mr. Vooch. And if there's inquiries of the actual engineering criteria that was implemented to come to these conclusions, we were already there. Now, I'm not saying that ship has sailed, we're never going back there. We think that that ship has both sailed and concluded adequately and thoroughly, comprehensively with the testimony. So my opinion of how he reads a definition is almost irrelevant. In the courtroom,
Well, I would like to hear what you're,
I understand. Well, I think he recited the definition, but I think he's taking a subjective angle on his interpretation. If we're in a courtroom, we're relying on the transcript, and I'm relying on the transcript of Mr. Stewart, Mr. McClellan, Mr. Vooch. I'm not relying upon my own whimsical thoughts as to how I'm interpreting an engineering code as an engineer. So I put relatively little stock in that, Mr. Chairman.
So, Mr. Chairman, while it's a legal question, it is based in engineering, and I think we need to hear from Mr. Vooch to get his interpretation.
So I'll start with Save Hamilton, the case law. My opinion as an engineer, that the case law is not providing for you a decision on determination of major development, is simply stating an understanding of the regulations, which is that matters related to public health, safety, and welfare are part of the principal prongs of preliminary approval. They are under the strict jurisdiction of the local board and not a higher agency. The reference in Save Hamilton is specific to the fact that that determination is not to be deferred. If you look to the Cox book, you'll find references in the Cox book specifically related to the same, and other more recent decisions such as Hoboken versus Shipyard, which challenged that and somewhat uprooted that. And it is a heeded warning to the boards, heeded, right? Not H-E-A-T, but heed, to heed a warning, that you should consider that under your jurisdiction and not defer to other agencies or changes in rule promulgations for the effective date of a filed application to you. And where this comes from is the 1972 Clean Water Act. Right? The Clean Water Act established EPA's Stormwater Phase 1 rules. That was in the early 1990s. In the early 1990s, under Phase 1 EPA, major development was defined at a federal level. It was defined as 5 acres or more of disturbance. That then required the creation of programming to hand down to states and, I don't want to get the term wrong, but the native nations to regulate major developments at their level to the equal or greater standards. Similar to think of of our state government, what they hand down to us at equal or greater requirements. Hence why now we have minor development standards, because we find them appropriate, not because the EPA or the state required them of us. In 1997-98, Phase 2 rules came out from EPA. Phase 2 rule promulgation changed the major development standard from 5 acres to 1 acre. It reduced that standard. It also made a critical determination that populations of 100,000 or less were to be considered small MS4s and to be regulated under the MS4 program.
what's
right?
MS4?
The MS4 program is our storm sewer program. We, as a municipality, are tasked under our MS4 permit to review these applications. The stormwater rules of our state came out of that 98-2000 rule promulgation from EPA that required that we address our Flood Hazard Control Act, our freshwater wetlands, our stormwater rules, and all of these rules that you've seen most familiarly in 2023 and 2026 under the Murphy administration be amended, and also prior in 2021, green infrastructure. So that the infancy of our stormwater rules came out of the EPA major development 1 acre threshold. And so we look back about 30 years of history to what we consider major development 1 acre, and it's been consistently the minimum standard applied from the top down. And at the bottom level, at our level, it's public health and safety. So it's our determination, even when there's a DEP permit that has to be obtained. And this is a little bit more education outside of just this discussion. It's important for you to understand that when a DEP permit is required, DEP's stormwater management reviewers are looking at the stormwater management in the limited purview of whether or not it is appropriate for the issuance of the permit at hand, the flood hazard permit, the wetland permit, whatever. It is not for the totality of the development and the full level of public health and safety. That is this board and under MLUL, your jurisdiction or our planning board's jurisdiction. And so that's what Save Hamilton says. It says, don't forget that you shouldn't punt to somebody else the principal prongs of preliminary approval, right? It's messed up more often than not in our state, unfortunately. I've been in other venues on that side of the table having to remind people of it. And I've been on this side of the table having to remind people of it. There's a certain level of prudence that's dictated. And that prudence goes back to, with a preliminary and final site plan, an amended preliminary approval that may be warranted and necessary after you go get a DEP permit because you've changed the land use component or the public health and safety of the application. So if you can't satisfy the stormwater public health and safety at the board locally, when you go to DEP and come back, you may often need an amended approval, but it's not often identified. As it relates to this application, we heard testimony from Mr. Stewart and his associate, Mr. McClellan, regarding the overall site design, the history since the Bruins took over the property and what they did without permits, identifying and then trying to rectify that with a survey of record and an understanding of what the historic footprint of the site was. We also heard similar testimony from the objector's engineer dating back further in some aerials and then trying to reconcile shapes that were proposed by both. And as Mr. Cali said, if this was to be determined in a court, we're going to rely on the transcript. So I'm going to try to rely back on the recollection of my prior testimony to this board from our last hearing. The overall net disturbance of the property and the overall net impervious increase, it's 1 acre of disturbance or a 1/4 acre increase of impervious surface or regulated motor vehicle surface. And we're looking at time of application for 2023 rules. So we don't have the redevelopment of existing areas in play. So if you have existing, in the 2026 rules, if you have new pavement going in place of old pavement, that counts towards that 1/4 acre. That's a big difference moving forward. But I reference that because I want you to understand the history of this disturbance on this site. In the last 5 years, it's a little more clear. It's the activity since they took over the property and they degrubbed areas that had grown in. And before that, we see a development pattern that was rather expansive of the property. With that prior expanse on the property, there was impervious cover of gravel surfaces in many areas. And that's what I keyed into with Mr. McClellan's testimony, that there was tract areas that were highly impervious and highly compacted and resistant to infiltration, so generate high runoff. And in those areas, many of them also had gravel laid down and tract prepped areas over time. Those areas were reestablished with vegetation, but that vegetation was reestablished through the gravel cover. So reestablishing those areas back as gravel is still a net neutral on the impervious increase. So I think on the grounds of the 1/4 acre is more specific to areas that were previous impervious prior to 2020, prior to 2022, 2023, when this applicant took over. and its reestablishment of those areas, I find it to be mostly a net neutral replacement. The overall 1 acre of disturbance, somewhat similarly, is over prior areas that were historically disturbed. Many of the activities can be segregated into 2 parts. The first part being property maintenance and taking back, reclaiming the property from what had been abandoned and had been grown in, right, over time. And then the establishment of the footprint of the proposal you see in front of you, right? The former being probably on the fringe of where we would, if we cumulatively added these things in, to the latter, we'd be going from that, I want to say it was 0.8 acres in land disturbance from Stewart Engineering's testimony, into an area that we're getting closer to that 1 acre or exceeding it, and which would align with the objector's testimony. Again, all these areas that are being reestablished for the programming today are areas that were part of the site's 80 to 100-year history. And I'm confident that most of this is restoring the site to a prior footprint, a prior established footprint that had operated under major development, operated as a facility previously and was lawfully existing. And so the net changes on this site, I don't believe constitute major development. I believe we have a land use disturbance threshold that was testified to at 0.8. We have an increase in pervious coverage that was testified to as a net decrease, but I think it's more conservatively. You could understand that there were some increases of those areas, not exceeding a 1/4 acre. In the event that this, I believe we have a minor development. The design of this site is meant to address stormwater runoff from a overland flow, direction of flow, maintaining drainage patterns, and improving drainage from the site to wooded and regulated areas that won't be disturbed in the future, won't be developed in the future, mostly to the rear of the property, and areas that therefore won't impact directly existing neighbors or public lands, or the potential for development of those lands. If we were to consider this a major development, the analysis that's required is going to be a comparison of existing to proposed with an existing condition that was well documented in the testimony in front of you previously as being highly resistant to infiltration and generating high runoff, including soil testing that was referenced, which I think the intent of that testimony was in first priority to discuss the lack of infiltration and the high generation of runoff. And in so, trying to also identify it as an impervious surface. If we just stick with that first part, the highly resistant to infiltration and generating runoff, you have what we'll call a high baseline hydrograph on the existing conditions. The proposed conditions, in comparison, are going to be similar land cover, similar intensities, and so you're going to have similar hydrographs pre and post. It's most likely they would have an opportunity to comply with what we call curve under curve, which is what you do without mitigation, where you identify that the site will drain similarly and the site will not exceed at any point the existing runoff pattern, the existing hydrograph, the distribution of the storm as it runs to the discharge point. If they were to design BMPs to mitigate that and do what we call peak runoff mitigation, right? So we meet the peak runoff standards by decreasing the peak and attenuating out the volume. You're looking at 2 similar volumes that are then, right, in both conditions that are then being attenuated and dragged out. You're That management, if they were to do that design, the design on this site would be in a few located areas around the parking areas to run off naturally into a basined area, probably a shallow, wider area of an infiltration bed, which we now know is resistant to infiltration. So that water is not likely to then infiltrate, but instead is going to need to go through the outflow and attenuate out. It's going to extend the time of that water on site and then attenuate it out slowly and leaving the water on the site as opposed to shedding it from the property where you're going to have activity of retail and other activities. I don't believe that if they had to do BMPs, it would change the layout of the programming to the extent that it would affect this board in their land use approval. The consideration of a land use approval for, variances requested and other aspects of the layout or the programming and what parts of the site that would be in. I think that's relatively static and confident here. And so my position is I find it to be a minor development consistent with the testimony provided by the applicant. If that was to be challenged and overturned in court, the appeal on that, I think, would not warrant a significant change in the approval of what you're providing. The contents of the plan, if then redone because it was determined they had to be, I think would be the same substantive application in front of you for zoning purposes and programs.
So basically what you're saying is that the runoff is not going to change. And if there is any change in runoff, it's going to be very, very minor with a very small increase or possibly even a decrease.
And it's important to understand that the impervious surface increase, the quarter acre part, the motor vehicle part, is what generates the water quality requirements, right? And then any of them, the 1 acre or the quarter acres generate the water quantity side of it.
Mm-hmm.
The water quantity is the mitigating the flood risk, the impact to others. The water quality is the impairments to streams and other waterways. That water quality has been eliminated from this discussion and analysis really by discussion from both the objector and the applicant's engineer. So we're talking about managing the increase in runoff from the site, which I find by theory and understanding of the site conditions will be relatively minor compared to the normal land disturbance, right? When you have a virgin land and you disturb those wooded areas and then you take high infiltration areas and you turn them into impervious cover, you're generating a giant quantity of volume comparative to the existing condition that needs to be mitigated. The purpose of defining something as a major development and to requiring the mitigation is to ensure that you're not creating an adverse impact to the public. I don't see an adverse impact and an issue with public health, safety, and welfare under the principal prongs related to this discussion of major versus minor. I think it's a technical matter that I've made my interpretation, and if it was the opposite, it would not create a concern for principal prongs of preliminary approval.
Okay. Do you wish to respond to that at all?
Yes, very briefly, and I certainly am not going to get into, and the board doesn't want me to get into a debate with Mr. Booch, and that's not my goal at all. I mean, first of all, we too will stand by the record. That's what we got. We have the record. We stand by it too. Along those lines, is my letter part of the record?
Yes.
Okay. And the last two things I would want to say is there was nothing whimsical about this letter, and it was not for purposes of delay. It was to raise what I think is a very serious issue. That's all I have to say.
Okay. Thank you. Mr. Cowley, any response?
No, sir.
Okay.
So just so our record is clear, I think we'll mark Mr. Rosenbach's letter as the next exhibit on the objector's list. I have 013.
That might be right.
So that'd be 013, right?
Yes. Right. Okay, at this point in these proceedings, we are going to open up this meeting for public comment on this application. So any person wishing to be heard or make a comment about this application, please proceed up to the microphone.
Mr. Chair, can I just ask you a question before we do that?
Sure.
It's two documents that were in our packet for tonight. I just want to get clarification on them. One was the noted New Jersey stormwater definitions, and the other, the Morris County Soil Conservation District Soil Erosion and Sediment Control Notes from Stewart Engineering. Were these new additional documents that were being provided to us? Or was there going to be any discussion on them? Or were they just supplementing something that was owed to us in the past?
Yeah, so what that was, I can handle it, Mr. Chairman, and certainly Mr. Rowland can add on to that. This was the backup data that supported Mr. McClellan's testimony at the last public hearing, where we were talking about the coverage changes and the plan details in the context of not a major development, because there was a question as to whether or not the bulk table would be updated to reflect those conditions. That was prepared by Mr. Stewart. That was submitted today. He had a one-page document today where he submitted the delta of that coverage, which is still downward adjusted from existing conditions. I don't know if that answers your question, Mr. Goldberg, but it really just augmented prior testimony.
Just to augment, okay.
Yeah, and for the record, while we're marking things, Mr. Chairman, Rich, can we mark that document of Fred Stewart's office dated today, May 18, 2026, into the record for the applicant?
Yeah, so we have the zoning requirements that, I guess, correspond to the plan last revised March 26, right? That is from Mr. Stewart, dated today. We'll mark that as A8.
Thank you.
Have you seen that document?
Do we have another copy to hand them?
These two documents? That one.
Dated today.
If I may ask,
From the microphone, though.
Are these brand new proposed calculations that are either the same as or inconsistent with what's been previously shown during the past many months?
So please correct me if I'm wrong on this, right, Larry? But we had asked for the zoning, updated zoning chart based off of the March 26th revised plan. Now, the March 26th revised plan shows that front plant area, right? In the revision of March 26th, it shows it a little differently than the original plan, which only had a single path through it.
By the way, Mr. Earl, I must say that when we were here last, and there was a reference in testimony to the March 26 plan, I'd never seen any March 26 plan.
Yeah,
It certainly
so-
wasn't an
so I
exhibit, it
looked
wasn't
into
made
that
public.
A little bit. Let me just clarify for the record where I think we stand on that, and Ryan's going to correct me if I didn't get this right here. But as I understand it, the March 26th plan, prior to its revision date of March 26th, was submitted to the board in digital form as a proposed exhibit on February 27th. And then, if you recall, our February meeting was canceled due to the snowstorms. And then we went into March, and in March, I think we had a lot of objector comment and testimony, and they never got to the point of reviewing this plan that they submitted in a digital format. And then it was subsequently revised to March 26th, although it doesn't say it just says update plan per site conditions. But when you go back to the February version of it, it has the same path configuration within the plantings area, right? And at the last meeting, the discussion was, look, if we were to vote at the last meeting, we had the plan that only had the single path through it,
Yes.
right? Physically in our hands. The digital copy of the plan had been submitted, but not a physical copy. And they got kind of, I don't want to say cut off, but never got to it because hearing that they were going to introduce that at was really taken up mostly by objector testimony. And then Mr. McClellan testified, and he reverted back to or discussed the March 26th version of the plan, which had technically been submitted in digital format, but not in hard copy to the board.
As I said, I noted the reference to the March 26 plan. I was not aware of a March 26 plan. To this day, I have never been provided a copy of any March 26 plan, and I've never seen it, nor has the public, to my knowledge. And talk about delay and talk about prejudice. Here we are when the applicant has already closed its case.
So, Brian, was the February plan that was submitted digitally on the website?
No, it was not.
Okay. Was this plan with the revised pathway put on the site at all?
The March 26th revision wasn't received in hard copy until May the 4th, and it has not been available digitally on the website.
Okay, but the prior version, because this is the revised date, right, the one that was submitted digitally in February?
It was received digitally February 23rd and planned to be introduced as an exhibit. It was never introduced as an exhibit and was later revised by the March 26th version.
Okay, and was it provided to the board?
The original February 23rd version was provided to the board, but never got introduced as an exhibit.
Okay, understood. Right?
File document, yeah.
Oh, so let me again say that we've never seen it. It hasn't been made available to us either as a courtesy copy or in any other way. And here we are at what is supposed to be a final determination by the board, where apparently the board is going to be asked to vote on plans that we've never even seen.
Well, so again, I think the difference in this plan is the path where plants are staged, right? And the additional pathways resulted in a different impervious percentage.
Still downward adjusted from the prior condition,
Right.
and it creates no additional relief. And it was on file with the board, and a courtesy copy, while that would have been a nicety for me to provide, it's not required, as you know, so.
Yeah, it would have been nice to send it.
It's not, I admit, it's not required.
Not to
I wouldn't
belabor the point,
expect
but
one.
I've asked for courtesy copies of objector exhibits for months, and I never got them from Mr. Rosenbach, so you're gonna get the version of me that you deserve, and that's what he got here, Mr. Chairman.
Right, but at the same time, things have been introduced into evidence in these hearings. And certainly this hasn't, either version of this plan.
It was a filed plan, filed more than 10 days ahead of the public hearing.
No.
It warrants testimony. Mr. Buch can advise if he needs to hear testimony to walk through that front yard area that creates no delta of relief. We would gladly do that, but it doesn't warrant that. It changes no relief.
It warrants us having at least the opportunity to
Yes.
look at it and to compare it to the existing plan. And I don't need Mr. Cali telling me how to represent my
Well,
clients.
you had 10
Okay,
days.
Yeah, I
Just,
think
uh,
council need to direct their comments to the dais, okay?
So
Not
it's
each
filed
other.
more than 10 days out, and the applicant is comfortable with that position, Mr. Rowland, Mr. Chairman.
It would have been very nice to send Mr. Rosenbach a copy. How do you want to proceed with this?
So, Mr. Voigt, do you think you need any testimony on the revised, March 26th revised plan?
I do not. The area that's being referenced is, right, the front yard, the front lawn. It was originally proposed with a brick paver path that was serpentine straight down, and then you would kind of double back along that path. The objector's engineer on his exhibit identified that as 1,600 square feet of brick path. The Stewart exhibits show that area in a comparable size. It's a different shape, but it's redistributed over that area, and likely increased in impervious cover, but the total calculations are still showing are now inclusive of that area and showing the net decrease on the site. So I think the entirety of that area was accurately shown as disturbance by both objector and applicant, and the discrepancy is over the difference in the impervious proposed over that area, and it doesn't rise to the level of the quarter-acre threshold.
All right, do we have a copy of the March 26th plan that we can hand Mr. Rosenbach right now?
Can I ask Mr. Vuch a clarifying question on that?
Yes.
So you say it doesn't rise to the threshold of a quarter acre of additional impervious coverage?
Yes.
Is that just for that area, or is that in terms of the total
Cumulative.
site, cumulative?
Cumulative to the site.
For the site.
The difference between the two versions
This is the original.
doesn't then cumulatively add to increase over the total quarter acre.
Right.
And as noted on the letter dated today from Mr. Stewart, there still is an overall decrease from existing.
We give them 10 minutes for the-
Yeah, yes, but before we do that, I think we should mark the March 26th plan as an exhibit, so we're going to mark that A9.
Percentage.
Right, and then the letter that's already been marked A8 really corresponds to the plan that's now marked A9.
Very good, thank you.
This is the new one? Yeah.
So that having been said, I think we're going to take like a short recess to allow the objectors' counsel and the objectors to review these documents that they have not seen before.
Thank you very much. We appreciate that.
Okay,
Let's,
well, we're in recess. Lamar Township Board of Adjustment for May 18th, 2026. We have roll call. Roll call.
Mr. Goldberg.
Here.
Mr. Trachtenberg.
Here.
Mr. Williams.
Here.
Mr. Schuster.
Here.
Mr. Benoit.
Here.
Mr. Kramer.
Here.
Mr. Woodford.
Here.
Ms. Simmons.
Here.
Mr. Evangel. And our board attorney, Mr.
Here.
Oler.
Here.
Mr. Voigt, our engineer.
Here.
Ms. Keller, our planner.
Mr. Schuster needs to turn his microphone on.
Oh, so do I.
Oh, thank you.
You're on.
Here.
Okay, Mr. Rosenbach.
I've had a chance with my clients to review the plan that is stamped received May 4, 2026. And of course, I have heard Mr. Vuch's comments or testimony, however you wish to describe it, concerning the plan. But I do have a question, and my question is whether this plan shows or purports to show what is on the ground at this time, or whether, like was mentioned a few meetings ago, the board might approve something which isn't what's on the ground, in which case the applicant would have to perhaps undo things. So I would like to know some testimony from someone. And the reason I ask, Mr. Chair, specifically, is because there's been testimony going back months that this entire front area where the one serpentine path has been replaced by a more complicated path is gravel. And that's an impervious surface. And so I would like to know what's actually being counted up front, or whether, as far as this plan is concerned, there's grass here. I'd like testimony.
Mr. Kelly?
Yeah, look, I'm not surprised to hear that there's more vetting being sought by objectors' counsel here. It's a minor plan change, a minor programming change showing a front walkway. The balance remains the same, and the only supplement to the board was confirming that delta of impervious coverage change. Again, it's not a variance issue. It's only even site plan reviewable because it's part of this pending application. It is a small item. It is incredibly low-hanging fruit, and the applicant is not intent on walking down this road with the objector to delay, protract, or continue to overwork and overfunction that detail. We are resting our case, Mr. Chairman, and we're resting our case with that detail in play that Mr. Vuch confirmed. Cumulatively doesn't make it a major development. It's still a minor. Doesn't change any variance relief. The delta of impervious coverage continues to come down, period.
But you would agree that if this plan were approved, that what we now have before us from revised March 26th is what would be built. It may already be built. I thought the intent was that this was reflective of what's on the ground now.
It says that.
But if it's not, it would
is,
be.
and
right?
will continue, correct.
Okay.
The ultimate outcome is that detail in the front yard area. It does happen to be there today as sort of a meandering path for folks to come and walk in and out to check the available stock.
Right.
Okay, and that path is composed of what? Is that pavers?
It's paved.
And what's the balance of the area?
The balance?
Yes, of the front area.
I don't follow the question, the balance.
Part of it is pavers, the path is pavers.
Oh, the balance of material.
Right.
And crushed
Yeah.
stone. And the
Crushed
loose,
stone,
like a
and
land?
it's the same material that was out there under the prior conditions when the pathway was different.
Okay.
Yeah.
So there's no change in the materials on the rest of the area, the front area.
Well, I'll say this, we'll stand by the record on this too, which will show that that was always grass and shows pictures now very vividly showing that it's a gray, gravelly type of substance. And I would hope that if the board does happen to approve this, and by the way, I hope it doesn't, but if it does, I would hope that somebody visits the site. And if it turns out that there have been misrepresentations to the board, at the very least, to make the applicant undo it.
Well, again, what they're asking us to do is approve this plan last revised March 26th.
Yes?
And if this is approved, then this is the plan ultimately that would have to be on the ground upon inspection for a CO to issue.
Correct.
Right.
But I know that the board is not an enforcement agency.
Right.
So,
But this is what the board is being asked to approve.
Okay,
understood?
all right. So now, where do we go? Public comment?
Yeah, I think we're up to comments.
Okay,
Yeah.
once again, we're back to whether any member of the public wishes to make any comment or statement regarding this application. Please come up to the microphone, identify yourself, be sworn in, and then say what you want to say.
So would you raise your right hand, please? Do you solemnly swear that the testimony you will give to this board will be the truth, the whole truth, and nothing but the truth?
Yes, I do.
And your name, please?
My name is John Peel. I live at 15 Prospect Place,
And can you spell your last name, please?
P-E-E-L.
Thank you. 15 Prospect. Okay.
Okay, proceed.
So I'm here as a neighbor. I also happen to be a licensed professional planner and an environmental consultant for the last 40 years. I've lived in my house for 30 years and have seen the old florist property numerous times in its natural state. What I find curious here is that this place is already built, it's fully operational, and it's still got a use variance pending here. And it's curious to me as to how that got this far. It's basically the applicant has built the project and it's operational. Just curious how that happens without actually having the approvals. So that's just one comment. I've heard noise events over at the property 2 or 3 times, which have been offensively loud. One day on September 13th, I had my new granddaughter. She was a newborn child there. A fight broke out in the parking lot. It better not happen again, or I might be involved in a fight next time.
When you say a fight broke out, can you give any details? Or just, what'd you see, what'd you hear?
Yeah, there was a screaming and yelling from some of the neighborhood people and from the operators of South Street Gardens. They came over onto the parking lot property where the old school was, and a fight I had to break up the fight, to be honest. And this was during a party for my little granddaughter. You were just talking about the front yard area in South Street Gardens. It was always a lawn. I've been living there for 30 years. It was grass. There was no gravel there. That was a pervious area. And the impervious calculations, if the NJDEP gets involved in this, it's going to be very interesting. I've got experience doing impervious calculations and submitting applications to the DEP. And the proofs to the DEP for what is considered impervious are very high, very difficult. I think it's like 0.02 of an inch of rainfall in 24 hours. If it doesn't percolate, it's not impervious. So my understanding is that the DEP is actively involved in looking at this property as we speak. There's an enforcement action, I think, that's pending. The enforcement group, deal with them all the time too, as well as land use regulation. Enforcement will kick this to land use. And if the land use guys require any kind of a permit or a waiver as part of a letter of interpretation process, I don't think that's ever been applied for yet. The DEP could consider this a major project based on their regulatory authority for determining that. So, it's disturbing as a neighbor to see this process go through what it has gone through. It's already built and functional. It's basically the applicants has basically said, we're getting our use variance, so just get out of the way. That's what it looks like to me. So I don't have a lot more to say about that, just that there's been some misinformation. This thing went from a non-conforming use expansion to a nursery center. I thought that was really nice. They did a beautiful job at that, but they're pushing it too far by having an event center with noise late till 10 o'clock at night, 5 days a week. It's offensive. The noise had better not continue is all I can say. It's been quiet since September, I'll tell you that. That's really all I have to say.
When you said there's an enforcement action, can you expand on that?
Yeah, somebody made a complaint to the NJDEP. They have been to the sites, and really not that funny, Mr. Kramer.
Yeah, I think we should.
Excuse me?
We should.
Wait, I'm being addressed here. Excuse me?
Yeah, you're laughing at what I'm saying.
Not laughing.
All right, so there's an enforcement action, whether it's valid or not will be up to the DEP, but that has happened. Correct me if I'm wrong, I don't
Okay,
think the
so I
applicant
think we
has.
should just go to our engineer who has some information about that.
Okay,
So related to the enforcement action. I was contacted by DEP enforcement, what's now probably 2+ weeks ago, related to a complaint that was filed specifically for disturbances of areas to the rear of the property
Right.
that were identified, that the complainant identified as being in regulatory areas, wetlands
Right,
specifically.
is that referring to the areas at the rear where that wetlands area?
Correct.
They said had been pushed in and was recently filled?
Correct. And so I went through discussion with DEP to provide them as much context and background of the application to the filed documents on record. And our board secretary was coordinating to give them access. I directed them to our website to the documents that were on site, and then we were looking to compile any additional information that DEP requested from basically the application record. If anything they wanted to see on the application record. Had informed them that the plan sets submitted to the board include a delineation by an expert working, a wetland delineator that was working with Mr. Stewart's office as part of the survey and site plan application set. That included wetlands on the ditch area between them and the Prospect property,
Right.
and then into off-site areas into the paper street.
Right.
And that's where they were delineated on the plan sets. I also informed them that the wetland delineator, an expert for the objector, had indicated in their testimony that they believe that those wetland flags should be closer to the property, if not on the property. And that was essentially the basis of what DEP was looking to investigate, was if they believe that that representation was accurate to where the wetlands are in the rear, and if there was a disturbance that had occurred both on-site and immediately off-site to wetlands and or their buffers.
Okay.
I had not heard back from DEP as to a result of their findings, but I understood that Mr. Cali coordinated a meeting for enforcement to meet with the owners of the property and have access to the property to get access to whatever areas they wanted to access. And I understand that had occurred.
Has that occurred, Mr. Kelly?
That has.
Okay. And you haven't heard anything back from DEP at all?
No, sir.
Okay. All right, anything else you wish to?
Yeah, going back to one of the technical TCC meetings, I think the board planner originally recommended that the applicant get a DEP letter of interpretation. I don't know if that's ever been applied for, but that's the one that sets jurisdictional limits, not a consultant like me, not their consultant. The NJDEP determines what their jurisdictional limits are. And again, I don't think that's even been applied for yet. I've done about 1,000 of them. I know the process really well, and there's no record of it. So enforcement's involved. They could kick it over to land use if they think there's an issue, but land use will be the final arbiter. If a permit or a waiver is required by land use guys, then the DEP will get to look at it as a major or a minor. They will determine if it's a major permit or not, or major development or not, at which point the impervious calculations are going to get very interesting. That's really all I have to say.
Board members, any questions of this witness?
The only question I would have for Mr. Peel or Mr. Cal, if they know, does the NJDEP, well, after they come out and do the assessment, say, you'll hear from us in 90 days, 180 days, 12 months? Any sense on the ETA
They did
for
not
this?
specify, and with them, it could run the gambit of a long time to a very long time, so we're uncertain. Although the young agent who contacted me, coming out in the field, she was quite diligent, so she came out within a matter of days of, speaking with me. So you want to hope that they're going to do a relatively fast turnaround for that agency, but you never quite can tell with the department.
Thank you.
Okay.
Agreed.
Any questions of this witness?
No, sir.
Questions or
Thank you.
questions? Okay, thank you. Your name, please?
Beth Fissel, Fissel.
Ms. Fissel, would you raise your right hand, please? Do you solemnly swear that the testimony you will give to this board will be the truth, the whole truth, and nothing but the truth?
Yes, I
Thank
do. So help me God.
Your address?
5 Catalpa Road, Morris Township, Convent Station. I wrote down because I tend not to be that good at just off the cuff. For the most part, beyond corporate and numerous Board of Education meetings, I've attended a handful of adjustment board meetings in the last 4 decades in the localities in which my family has lived. My usual presence was to advocate for those who could not advocate for themselves, sometimes much to the dismay of the boards I was addressing. And for me, that was okay because it was, in my eyes, the right thing to do. I have watched and listened to past Morris Township meetings to get a sense of how the process works here. The patience shown for this process over the last 9 months is, in my opinion, beyond normal human capacity. I am here to advocate for the approval of permits, variances, and whatever is needed for South Street Gardens to continue to operate and open as a garden, home decor, event, and cafe space. In the last meeting, several experts informed the public and board of the issues with decibel levels of several scenarios. I heard that there was a valid performed test at the proposed venue at South Street Gardens. A speculated, albeit statistically acquired, decibel level from the venue by the opposing side to me is hardly a viable definitive conclusion. As a resident, I have heard people complain about the helicopters that fly over our homes, decibel levels 80 to 100 dBA. But these helicopters are flying precious cargo, someone's mom, child, spouse, or for immediate medical attention. How lucky are we? Our outdoor generators, 60 to 70 dBs, which I hear tested every month or used during power outages, which happen far too often, but grateful that we have them. Ginty Field events. The entire surrounding neighborhoods hear the loudspeakers, bands, games, and we should all be grateful and happy and enjoy the fact that many are getting together to celebrate, appreciate, and relish the ability to bring communities and people together. We hear them blocks and blocks away. As for the concern surrounding the water spring table moving, did all this happen before the landscaping and building? It has to be a pre-existing condition following the abandonment of the property decades ago. There has to be a simple, amicable solution for the concerns surrounding this long outstanding issue. Think of what could have ended up at this property. Apartments, multiple stories high, with open windows, blaring speakers, lights at night. We have leaf blowers, lawn mowers, plow trucks, all items we use to enjoy our spaces and beautify our neighborhoods. At some point, we have to embrace the technologies that make us better. I heard cause of quality of life, and there are so many things that affect this. What adversely changes your quality of life? Stress, negative behavior, illness, pessimism, worry. I believe we're all culpable in working together to ensure the quality of life for everyone is acceptable, even though there may have to be some concessions for a few to embrace the community. Many, many of us are thrilled with the presence of South Street Gardens in our backyard. On a side note, regarding the issue from last meeting, or question comments, I counsel high school and college students applying for college or employment. Anything you post, write, or comment on the internet lives forever there for anyone to find, whether you delete them or not. We all have to be careful what we say, verbally or online. Is it possible for all of us to address concerns and work together to have a happy neighborhood? We are all too swift to jump and demean, attack, and fail to listen to each other and work together. I feel we have an opportunity to welcome a business that has made and will continue to make formerly rundown, abandoned, overgrown property a beautiful place that welcomes all and encourages everyone to relax, enjoy, and take in peaceful surroundings that make our town better. I would hope that as a community, we can come together to support and positively engage with a new business in our town or face future business owners taking their business elsewhere, and I wouldn't blame them. I'm imploring the Morris Township Board of Adjustment to please approve the permits for an all-encompassing business and venue space and an inviting, welcoming partner in our neighborhood. Thank you.
Board members, any questions? John, back, any questions?
I do, just a few.
You gotta come up to a microphone.
Yeah. So,
Yeah.
am I correct that you live in a single-family residential home?
Yes.
Am I correct that you live in a single-family residential
Just a second,
neighborhood?
Mr. Rosenbach, could you use this microphone right here so you're not like right on top of her while you're asking questions?
Sure.
Right over here.
That'll come out of the stand. It's just a handheld. There you go.
But at the bottom, probably. It timed off.
At the bottom.
The flat part of the bottom.
Hold it for a few seconds.
There you go. It's like nothing. Okay, hello.
You turned it on. Now it's on.
Okay, let's try it now. Okay, so let's start from the start. Am I correct you live in a single-family home?
I do?
Am I correct that you live in a single-family home neighborhood?
No,
Okay, what is the neighborhood?
I have condos behind us and apartments.
Okay, and so you have condos on one side and otherwise, aside from the condos, it's single-family homes?
Yes, and the nuns convent,
And how far is that?
150, 200 feet.
Okay. And so I gather from your testimony that if a single-family home near you were to sell itself and become a party center, you would have no objection. Is that correct?
Well, I wouldn't have an objection, but the problem is that they're like a third of an acre, so that's.
Well, leaving that aside, I gather that you would have no objection if there was a party center with a band 5 or 7 days a week, a few doors away from you. Am I correct about that?
Sure.
That's all I wanted to know. Thank you.
Gotta put the microphone back. Anybody else have questions?
No.
No, good. Thank you. Yes, sir.
Your name.
Yeah, good evening. My name's George Tellerico. I live on Blackberry Lane.
Can you spell your last name?
It's T as in Tom, A-L, ARICO. And I live on
Mr.
Blackberry Lane.
Talarico, would you raise your right hand, please?
Yes, sir.
Do you solemnly swear that the testimony you will give to this board will be the truth, the whole truth, and nothing but the truth?
Yes, sir.
Okay, and your address again, please?
24 Blackberry Lane.
Thank you.
And Blackberry Lane intersects South Street, pretty close to the South Street Gardens. So,
Just relax. Please let them answer.
Listen, don't listen there, just speak to the board, please.
so like I said, it's Blackberry Lane's pretty close to South Street Gardens. And I've been on Blackberry Lane for about 26 years. And I knew of the old site. It was a florist that I used to go to buy flowers, and then it just like kept decaying, and it was kind of sad. And we worried about what was going to go there. And then when South Street Gardens came in, we were happy because one, it cleaned up kind of a decrepit, overgrown site. Two, it preserved open spaces. Like we're all about open spaces in this township. And three, it saves us from having to drive to Morristown to, because it's a big pain from where we live to get to Morristown. You got to get on 287 and go to Lafayette. So we have a garden center right there. Get a cup of coffee, and to reiterate what the one of the other witnesses said, it could be a lot worse. Like 200 feet from my house, they're putting up 104 affordable housing units. I mean, if I could switch the garden center for 104 units, I would. So anyway, I just want to come out in support of their variance. And like I said, it's a nice place to visit, and I think it's a big improvement.
Thank you.
Sure.
Any questions? Mr. Rosebach, any questions?
No, I have no questions.
I think you have none. Okay, thank you.
Sure.
Any other member of the public wishes to testify on behalf of this application or oppose this application?
Hi, my name's Jocelyn Grizzetti. It's Grizzetti.
Ms. Grizzetti, would you raise your right hand,
Of
please?
course.
Do you solemnly swear that the testimony you'll give to this board will be the truth, the whole truth, and nothing but the truth?
I do.
Thank you.
Okay.
And your address, please?
Oh, sure. I'm 25 Blackberry Lane. I am wanting to speak in support of approval of all the variances and just moving this thing forward. I have no prior knowledge of this family or their businesses, their landscaping in Mendham, but my son worked for them last summer. And all I can say is they treated him like family. And I mean, they were true to their word that he had come in to apply. They said, come back, we'll give you a job. And they were true to their word. And I just, I found that very respectful. And I also feel that what they're doing to the area, I echo what everybody else has said. It's definitely beautified the area. I have been here before listening to our affordable housing and listening to the cannabis approval. I sat through all of those and I was too afraid of what might be there. So I find that this is a very welcoming and pleasant addition to our community. I enjoy walking down our beautiful Southgate Parkway that they renovated and walking over and just, perusing the home center, perusing the gardens. I don't mind grabbing a cup of coffee or an iced tea because that's wonderful. So I just, I feel for them. I feel like, it's just time to move on with this. And one last thing is I did ask about potentially hosting an event there. And what I was told was that they couldn't do it because it hasn't been approved, but that they were, agreeing, or like the noise ordinance for Morris Township is 10, but they had to shut things down at 9 if they were to get approved, so that everything could be cleaned up and moved out in time and before 10 o'clock to kind of meet the neighbors halfway. And I thought that was very respectful. And I don't believe, I would think I was also told like no loudspeaker systems or any bands would be allowed. I was like, listen, it's just like a little party. It's not a big deal. So I wasn't even thinking along those lines. But anyway, long story short, I just appreciate their presence in our community, and I think it makes it a nicer place to live.
Board members, any questions? Mr. Kelly, Mr. Rosenbach? Okay, thank you.
Okay, thank you.
Any other member of the public wishes to speak regarding this application? Seeing none, hearing none, close the public portion. So we should have counsel.
Mr. Chair,
Yes.
he's not my client.
Okay, do you wish, if you're not,
Yes.
well, then come up to the, I was asking if anybody else, you should have said something.
Sorry.
Hello, everybody. My name is Guy Ben Aaron.
Can you spell that, please?
GUYBENAHARON. I live in 18 Prospect Place.
Okay, would you raise your right hand, please? Do you solemnly swear that the testimony you will give to this board will be the truth, the whole truth, and nothing but the truth?
Yes, I do.
Thank you.
So I live in 18 Prospect Place for 11 years. It's been always quiet neighborhood. And it's been quiet since September 13. Before September 13 was quite a lot of events, and it's not okay. I'm sorry. I cannot watch even TV in my living room in peace and quiet. When they opened the garden center, I was all for them. I was very happy. If they did a beautiful job, they did a magnificent job, a beautiful job. And I can speak on behalf of my neighbors. We've all been very happy that they opened the garden center. But we're not okay with the events. All we ask is peace and quiet in our own home. I'm sorry. I'm not asking too much. The two people that have been here right now, Blackberry, I'm sorry. This is way, way far. I live in Prospect Place. I hear everything. This is not okay. Like, what are you talking about? Blackberry? Please open the map and see where is Blackberry and where is the garden center. Way far. I'm so sorry. All I'm asking to live in peace and quiet in my own home. I love my neighborhood. I get along with all my neighbors. I live in a great neighborhood. All I want to do is continue to live in peace and quiet in my own home. I don't think I'm asking too much. It's very simple. I'm not trying to close the garden center. I have nothing against them. They want to do a business? Go ahead, do whatever they want. I want peace and quiet. Is that too much to ask? I don't think so. Peace and quiet. I don't think nobody else can ask somebody simple like that. I'm so sorry. Peace and quiet. That's it.
Thank you. Any questions from board members?
I have one question. So, do you consider yourself to have had peace and quiet since September 13th?
Yes, because since we object, they've been quiet. But before that, there was quite loud events. If it's like during the day, early in the morning, even late at night, and that's not okay. I cannot even hear in my own living room. I cannot even listen to TV.
Since September 13th, though, everything.
Yeah, I don't remember quite the dates.
Okay, but roughly, there's been
yes,
no. Okay.
Yes, and if you're gonna approve those events, I'm sorry, this is not okay. I wish I was living in Blackberry, because Blackberry is way, way far. I'm so sorry. This is a joke, really bad joke. Thank you so much.
Thank you. Okay, once again, any member of the public wishing to speak on this application, we're not going to reopen it. Okay, close the public portion. So how do we want to proceed? Okay. Mr. Rosenbach, do you wish to sum up?
I sure do.
Thank you.
As you all know, I represent John Weisgerber and Eric Vieira, who each live on Prospect Place and who are opposing this application. And this is an application to place a quite substantial commercial development in a RA15 residential zone. And according to the application, this project will comprise more than 18,000 square feet of commercial space. And that will include a large retail store selling products, at least some of which are related to gardening. It will include, if approved, a 1,700 square foot coffee shop, and if approved, a 2,200 square foot event space. And this is being called a garden center. Everyone, I think we've all agreed there's no definition for a garden center. And although the RA15 zone includes agricultural uses, there is no contention by the applicant that this proposed development is permitted as an agricultural use. Now, when I say proposed development, that is, of course, a misnomer, as pointed out by one of the neighbors just a moment ago. It's not proposed, it's on the ground. It's been there for months and months and months. And in fact, it was running events until they stopped. So in a sense, as far as the applicant is concerned, this board is almost irrelevant because they're just doing what they're going to do. And nonetheless, though, they do need variances. And one of the variances, as I said, the right to allow the public to rent out space on their site to have parties has already been happening. Although, again, for the moment at least, it has stopped. Now, as a matter of basic law, I'm a lawyer, variances for commercial uses in residential zones are disfavored. They are to be granted only sparingly and with great caution. I'm quoting from the New Jersey Superior Court. And for a use variance, which is what we have here, there are two different things that the applicant has to satisfy, and they go by the term positive criteria and negative criteria, and they must both be satisfied. I find those phrases to be unhelpful, quite frankly, but that's what they are. And the positive criteria, that's the first half, requires that the applicant establish what are called special reasons for the variance. I believe that's right out of the statute. And on the other hand, for the other half, the negative criteria, the applicant must show that the variance, and here there are a bunch of variances, can be granted without substantial detriment to the public good and will not substantially impair the intent and purpose of the zone plan and zoning ordinance. And both of those, the positive and the negative, they both have to be proven, because if the applicant fails on either one, then the application must be denied. Now, in terms of the positive criteria, there are two ways typically to do that. Well, there's a third one, which is called an inherently beneficial use, but nobody's contending that that's the case here. That's like a church or a school. So there are two other ways. One is the general welfare is satisfied because the use, the proposed use, is peculiarly fitted to the particular location for which the variance is sought. So in this case, that means that this particular use, and the use, by the way, is a retail store, I think also maybe a gift shop, I'm not sure, a coffee shop, another use, a party space, another use, and I believe a food truck. So all of those things, they have to be peculiarly fitted for this particular location at 383 South Street. The other way is that if there's undue hardship, because if the use variance is not granted, then somehow for one reason or another, the property can't be used for a conforming use. And by the way, the law is also very clear that the economic convenience or advantage of the owner is not a reason to grant the variance. And so if I'm a business and I would like to expand because it'll give me greater efficiencies of scale, but I happen to be in a residential zone, the land use board isn't supposed to say, oh, you're going to be more profitable, therefore we will disregard our zoning code. Now, back a year ago, it's taken a while to get here, in May 2025, a TCC report on this application noted, and I'm going to quote it. It said, the TCC advised the applicant that a D1 use variance would be required to permit the proposed use. Again, D1 is not necessarily vocabulary that flows off the tongue of people. D1 is from the statute for variances. D1 is a use variance. And there's something called a D2, which is an expansion of a non-conforming use. So in May of 2025, the TCC advised the applicant that this was a D1 use variance. Nonetheless, 2 months later, in July 2025, the planning report provided by the applicant called this a D2 variance and basically said the garden center is a lawful existing use. And what the planner said for the applicant was, it's already there. It's a lawful existing use. It's not even in front of the board. The board has nothing to say about it. So all we care about as the applicant is the coffee shop and the party center. They call it an event space. I call it a party center. And that was despite the fact, again, that the TCC had already said to them, this is a D1 variance. And in fact, at the last meeting of this board, it was made very plain that the existing garden center isn't the baseline, that that's up for grabs too, and that the applicant has to prove every single stick of this application. Now, by the way, I will tell you that my clients, like the last person who testified and like other people have testified, actually have no big problem with the garden center standing by itself. It's a plus for the neighborhood. It's an expansion of what used to be there. But it's not bad. It's not awful. That's not where the quarrel lies. And we'll get to the quarrel. I mean, I think you know what it is. And so one significant point, though, is that the applicant and its planner had months and months and months, including the rebuttal testimony at the last hearing, to provide planning testimony in support of the very base use of a retail gift shop oriented around flowers or flower-type products. It never did. The only planning report this board ever received for the applicant was the one that presumed that the gift shop is fixed in stone, and the only thing this board had to worry about was whether a party center and whether a coffee shop were legitimate expansions of a non-conforming use. But it is not it's not a lawful non-conforming use. It needs a use variance. Now, one of the reasons that this is very important is because the TCC had also asked the applicant to look around and find other garden centers and see how they operated. And in fact, the applicant did what the TCC wanted, and the applicant presented comps as part of its testimony. We objected to them. I stand by those objections, saying that whatever happened on some other piece of property on some other town has no bearing on the particular facts of this case. But there's a more significant point, which is that what the applicant has said and what the applicant's planner has said is we need these things. We need the coffee shop. We need the party center because we need to enhance our operations, to enhance our revenue in order to allow what they call a garden center to survive because competition is so hard. Now, that would be okay, perhaps, if the garden center were already lawfully there. But the garden center isn't lawfully there at all in the first place. So what they're saying is, we want one variance for what we're calling a garden center. And because that garden center can't survive on its own, we want the board to give some more variances. We want to be able to serve coffee in a large coffee space, and we want to be able to have parties. So they're bootstrapping themselves from something that they shouldn't have in the first place in order to have 3 distinct uses, plus maybe a food truck. Now, one other notable thing about the planners, the applicant's planner report and testimony, is he never mentioned the fact that Morris Township has a master plan. He never referred to the master plan. You would think that there is no master plan in Morris Township based on the applicant's case. But our planner, Mr. McLean, he referred to the master plan, and he testified that in the 1994 master plan, most recently evaluated in a 2017 reexamination, its first goal is the preservation of the residential character of the community. And it has as another goal, the maintenance of existing commercial areas and restriction on new commercial development. That's what's controlling in this town. But you wouldn't hear it from the applicant because you didn't. Now, let's go back to this idea of the positive criteria. So it's the applicant's burden to show that this particular piece of land at this particular location is peculiarly suited for the purposes that it wants. So you could say to yourself, any of you could say, what's so special about 383 South Street that it needs a party center? And I suspect your answer would be nothing. There's nothing special about it. There's nothing about 383 South Street that says we are desperate to have a party center here and it belongs here. I think the coffee shop is slightly less gruesome in that I can imagine a business could want to be able to serve coffee, as long as it's really limited to the business, the customers of the business, and doesn't become a draw to outsiders. But there's nothing in the world that connects a party center to a garden center. Now, I know there was testimony, we'll try to have things that are garden themed. Okay. That would be great if there weren't weddings, bachelor parties, whatever, just general parties. There's nothing that says that a party at this place must somehow have a horticultural or agricultural theme. I mean, who has parties like that? So again, I say in terms of the positive criteria, which this board has to find, or it can't support the application, there's nothing on this site that says we must have a party center because this is the right place for it. Now, in terms of the negative criteria, that's the other half. And that's the half that says there can't be substantial detriment to the zoning plan. Let me say that New Jersey law is very specific that for a use variance, a board actually has to make very specific findings. The law calls it an enhanced quality of proof. That's their phrase. And there must be an enhanced quality of proof and clear and specific findings by the board that the variance is not inconsistent with the intent and purpose of the master plan and the zoning ordinance. I've already quoted the master plan to you. And this is inconsistent. It's substantially inconsistent with the master plan because, yes, if we concede that you can have a commercial space there anyway, that doesn't mean you just get to build it up and build it up and build it up. And by the way, given that there's no definition of a garden center in your ordinance, and there isn't, I mean, what's next? An ice hockey rink? A pinball machine? A pinball venue? I mean, there's no reason that there can't just be a grab bag of different uses that this applicant says we need these things in order to stay competitive. And each time they would come before you for a variance, I hope. Well, no, that's not true. They would probably do it, and then they would come before you for a variance. But the fact is that there is a substantial detriment to the master plan, and there's a substantial detriment to the neighborhood. Now, I think it is all very well and good for people who live nowhere near here to talk about how delighted they are to have this facility. Very nice of them. But they're not living with it. And what we have is a bunch of testimony showing how damaging this has been. One of the things was Mr. Vieira, who was so taken by the noise that he went walking around the neighborhood with his phone just to get the noise. And as he testified, you could hear the DJ, you could hear words being spoken by the DJ throughout the neighborhood. You've heard people say they can't have peace and quiet in their backyard. They can't have peace and quiet in their homes. We had an acoustical engineer, and our acoustical engineer, Mr. Zabur, ran a standard computer-generated program. He didn't cook it up for this presentation. And what that standard program showed was that based on the topography, based on the buildings, that what happens is it's just bad luck. That noise from the site gets funneled down Prospect Place. It just happens. It's bad luck. And so people living on Prospect Place end up hearing substantial noise. And he said that that was consistent with the testimony that Mr. Vieira had given. And by the way, the applicant, as part of its rebuttal case, put on its own acoustical engineer, and he presented different testimony, but I don't think he rebutted that point. And in fact, the most interesting point to me of the rebuttal testimony was there was a lot of questioning by the board of, well, if we allow these parties, how do we police the noise? What do we do? And one of the answers was, well, you know, we're good neighbors and we'll be good. And the rebuttal to that was, well, we already have evidence from last September that that's not quite the case. So then the answer is, well, there's a learning curve. We'll get better. And the question was, well, still, what do we do? What do the neighbors do if they're being barraged by noise? And the answer was, well, they can call someone. And I think that discussion took about 20 minutes. It's a long discussion, back and forth, raising these issues, which I'm glad to see were of significant importance to the board. But what I take from it is there shouldn't have to be a 20-minute discussion about how to control noise on a site where there shouldn't be noise. I mean, the simple answer is no noise. It's very simple. And so, for instance, let's say, I don't think there should be a party center at all, but at least it could be no amplified music. And I'm very glad to hear a witness, a non-party, telling us what the applicant told her about what they're willing to do. I don't know what the applicant has told this board. I think I've heard different things. But there just should be no amplified music. End of story. There should be no outdoor music. End of story. And if that makes it hard for them to run an event center, so what? It's in a residential zone. They don't deserve it anyway. So one issue is noise. And there's another type of noise, because Mr. Weisgerber testified that he hears, let's call it operational noise. He hears heavy machinery noise deep into the night. They hear noise early in the morning. And that is a different type of noise that wouldn't exist if this were treated as a residential zone and didn't have these types of uses. Now, Mr. Weisgerber also testified that there is excessive lighting. He was questioned on that, but he said there was excessive lighting. And there's a simple solution to that typically, which is you have shielded lighting or down lighting, or aside from maybe a skeletal bit of safety lights go off at a certain time. That seems pretty routine. So in terms of, again, the negative criteria here, there's noise that shouldn't exist. There's lighting that shouldn't exist. There's just commotion that shouldn't exist, as testified to by Mr. Peel. None of this stuff should exist, and these are all negative. It's a failure to satisfy the negative criteria part of this. Now, there's been a lot of testimony even today about the extent to which this site affects water runoff. I'm not going to go through it again other than to say that I will repeat, we stand by the record that we think that we have shown that this is a significant problem. I learned today that there's some sort of investigation going on. We don't know what it is. I can't make any points, score any points from it, but we know that at least it's being looked at. But again, we're contending that it's a problem. And again, bear in mind that it's a problem where the applicant has already done all these things without bothering to wait for something as trivial as an approval. Now, let me conclude as follows. I've said that my clients don't really object to the garden center, if I may use the term, in and of itself. But there's something else for you as a board to consider. My clients don't make a decision. They're not one of the 5 votes that are required for this application. You are. And the garden center too requires proof of the positive and negative criteria. And I've already said to you that they never provided those proofs. When the applicant presented its case, they presumed that the garden center was lawfully there. So you can comb through this record all you want, and you will not find any planning testimony that justifies a garden center on this site. So I can say my clients don't care, but that doesn't mean that you don't care. You still have a decision to make. And then otherwise, we are vehemently opposed to the party center. Totally vehemently opposed. And if there's going to be one by this board's decision, as I said, no outdoor music, no amplified music. They can do all the indoor acoustic music they want as long as it's indoor and the windows are closed and it doesn't invade the neighborhood. And as for the coffee shop, I've said we can live with that. Again, we don't want it to be a destination draw. We don't want the extra traffic. But if it in fact is a legitimate service, a legitimate perk for people who are shopping there, we understand that. You can't really object to that. And so the issues are then, aside from the outright denial of the event space, which we think should happen, the fact that there's no support for the garden center itself, and the coffee shop, which is sort of sitting off on its own, then the real concern is if you were going to approve this, despite these positions, and if you said, well, it's all been very interesting to hear all this stuff, but we don't care, or we're convinced by the application, then at the very least, limit the noise, limit the hours of operation, limit the hours of lighting, and do your best to preserve this neighborhood, this residential neighborhood, from this invasion, because that's what it is. I thank you for your attention.
Thank you. Council?
We're going to be incredibly brief compared to that, Mr. Chairman and members. We would like to get into respective deliberations and then discuss potential conditions of what could eventually be a motion on the application. You know, in short, I just want to sum it up at a high level, as this board knows we'd like to tend to do. I mean, the applications stand on their own, as does the testimony. Our objecting counsel took tremendous liberties with the recreation of the road that got us here. I don't agree with most of that. We're going to rely on the record. As I've said before, the record is what controls. And we've had compelling testimony on this hearing record. Compelling testimony stands solidly. It stands on its own. We don't need to bolster it now. You've heard testimony from Michael Tobia on 3 separate occasions, testifying as to the use variance relief on all of those. Michael is not a fly-by-night planner. He testifies regularly. He did not miss those proofs, so I'm not going to humor that with the recitation of the positive and negative criteria that was put in the record to date. But at a high level, I will say that I know the board is very familiar with this site, very familiar with the historic uses of this property. It's been on this property for decades. The board's also seen the eventual disrepair of this property for many years. And then along comes new ownership, proud ownership. Ownership that has a positive relationship with the neighbors and the community, ownership that's got pride in what they do on that property and off that property and how it looks and how it functions. This is not a back of a napkin application that was filed with this board a year and a half ago. This went through extensive vetting with the TCC, with the board professional staff, engineering and planning throughout. And this was a very well-conceived plan that the applicant brought forward to the board for a prospective enhanced use of this sizable property in an industry that was growing. And that was the point of the parallels drawn in that submission and the testimony offered from Mr. Tobia previously as to the other facilities that you see that are engaged in this garden center with some limited and sort of high-end event space component to it. A lot of people like what the applicant is doing here. We've had droves of folks supporting us at every meeting and in the parking lot. The point of that is the objectors represent what I think is a very small faction of detractors. And what you've heard from them has been thematically consistent throughout. From the witness, Mr. Vieira, from his counsel repeatedly, it's a parade of horribles. What if, what if, what if? You're going to see this, you're going to see that. It's going to be a nightmare. We haven't seen any of that yet. We saw some raw footage that we really couldn't analyze at any meaningful level from Mr. Vieira's cell phone and nothing more. And that was a good question earlier. Mr. Goldberg inquired, well, have you had any loud ruckuses since September? And nobody really said boo about it from the public. There's been amplified music on this property every day in that garden center out there, just playing ambient music in the background while folks are out there. You've heard our acoustic engineer, who actually did do a study on the property. The other acoustic engineer, threw up a pass and just said, well, it might land here. We were actually in the field performing the studies at a forensic level, and it works. The applicant comes in under those levels as proposed. Again, this was well conceived at every level, right down to traffic engineering that was undertaken to confirm that we could occupy this property with this use and the intensity would actually match the site. The proposal was comprehensive and a well thought out design. I mean, that's effectively the punchline we took away from this from the date we had a completed application before the board and started prosecuting it patiently before the board. There's been a significant investment to evolve this property with this continued non-residential use on this sizable lot. Now, while the investment is not dispositive as to the warranting of a grant of an approval, I think it is indicative of what foot forward the applicant is putting in this case. The applicant has consistently undertaken significant efforts to make this property work better for them, for the community, in a way that has been very mindful of the neighbors from start to finish, notwithstanding the limited detractors we have here with us. Once we're in this room, it's the board's case to hear as the Zoning Board of Adjustment. We realize that our neighbors are never going to have Thanksgiving dinner with us, and that's fine. We wish it were a better relationship. It's not. It's actually eroded even more since the start of the process. But what we brought to the board was our case, right? And like I said, we've had compelling testimony. The board heard from operational testimony thoroughly. We've had civil testimony a number of times on this case. You saw beautiful architectural designs and layouts of the structures, the existing structures that were being rehabilitated on this property. It's adaptive reuse, which is what zoning tends to like. We've had traffic and parking testimony on this from Dynamic Traffic as well, including an acoustic assessment prior to the last hearing that was submitted by way of a report and augmented through testimony of the acoustic engineer saying we had speakers pointed in every direction, we had that at full volume, and we complied at the property lines. That was the benefit of Mr. Mueller's analysis and testimony, which was uncontroverted by Mr. Zybura, I will note, who just essentially said, well, it could be this. We've also had planning testimony. You've heard from Mr. Tobia a number of times. I find it interesting that there's an allegation that there's a void in Mr. Tobia's testimony on the planning proofs. He testified as to the D relief on multiple occasions going back, over a year when this case started, including the submission of a report, which is effectively supplemental to the testimony. What you've got at the end of the day here, through all the testimony from operations through the full complement of expert witnesses, is a use that's been balanced, tailored, and tempered. And it's a use that can be met with conditions that are imposed to mitigate the impacts of that use. The applicant's been all ears from the start. I've had a running list of, a dozen, 2 dozen items. I know Mr. Oler has as well. I know the board would discuss them if we're moving forward this evening. And there are conditions which certainly do have a nexus and bearing on the relief being sought that could be imposed as a mitigating measure to the board's grant of that relief. That's what a Board of Adjustment does. If a board's inclined to vote favorably in an application, but has some reasonable controls that they want to put on that. The applicant is amenable to that. The applicant is not barreling forward here, just saying we're going to get what we want in an entitled manner. The applicant has succumbed to the process. Everything that happened in that field prior to the application, before any hammers swung, was met with permitting by the applicant. At every turn, when additional testing and reviews were sought, the applicant met them. Anytime Mr. Vuce asked Mr. Stewart to undertake X, Y, or Z, Mr. Stewart promptly did it. Again, thematically, the applicant has been working with the township on this property they proudly own. And that property is not going to turn into Animal House. It is not a party center. This is a high-end event space that's going to be under the control of the applicant for all events, both within the structure and the outside proposed events. The outside proposed events are proposed to be amplified. We realize that they might shut down earlier. We discussed 9 p.m. with the board. We realize it's not going to be 365 days a year for the outdoor events. There's going to be meaningful controls on it, not just for the township, but for the applicant. The interests are very much aligned in that respect. But we know that this site, its configuration, its pre-existing use, what the applicant wants to do here, can all be reconciled under the code, and the relief can be granted reasonably with the imposition of reasonable conditions. on that. And I'm sure we'll talk about those shortly. The proposed use certainly doesn't undermine the integrity of the composition of this area, nor does it challenge or neglect to address any of the issues raised in any of the professional staff reports throughout, both from, Mr. Gooch's office, Ms. Keller's office, as well as the complement of other reports the board had prepared on their behalf throughout the process. All of the applicant's professionals have agreed to work with the board consultants where there was a divergence, or else the board consultants have agreed with the conclusions drawn by the applicant's experts in those reports and through the testimony. So at the end of the day, again, Mr. Chairman and members, I keep coming back to looking at this as a measured proposal, supported by the extensive filings, the time, the studies that were all undertaken, not speculative, but undertaken on our property, not a drone flyover where there were a bunch of assumptions made or anything like that via off-site observation from our objectors, experts. I realize they have a limited world of what they can work with, but we're working with hard, objective data, and it works. And it can certainly work on this property through a grant of this board with proper controls to ensure compatibility with the varied land uses that certainly are around us to an extent. With that said, Mr. Chairman and members, I want to thank you all for your time here. This has been a very long hearing. I can only think of one longer we've had in this boardroom years ago for the Unitarian Church application. That might have been only slightly longer than this one, but we want to thank you for your time. The applicant is incredibly eager and hopeful to get up and running in a meaningful way in comport with the plans that they've prepared, and they are incredibly excited for this board to consider the application that we're finally at this finish line, Mr. Chairman and members. But you folks have sat on a number of nights, late nights, mostly on Mondays. It's not easy, so I want to personally thank you for sitting and hearing it. I know the board knows this case well. I know you've heard the thorough testimony of the expert witnesses. I'm not going to rehash any of that, Mr. Chairman and members, this time. We'll rest our case, and I guess, again, we might be discussing if and when that there's a motion when we start talking about prospective conditions. I do think that is an important point of this application, Mr. Chairman, is what are the tailored conditions that could be implemented to control the relief that's being sought here? Because we're not seeking a carte blanche without any type of measure of control. We realize there's got to be controls at some level. Yeah. So we look forward to discussing those with the board shortly as well.
Okay, I think what we should do, and I asked Mr. Oler to concur on this, is should we discuss the conditions before we do any kind of motion, or should we have a preliminary motion as to should we go forward with listing conditions, or just have a general discussion on that?
Well, I think we could discuss conditions because there were many topics that came up that we didn't really reach a determination on, but it's a topic that the board still needs to discuss. So yeah, I think we should have those discussions. And as we heard from Mr. Rosenbach, I think, the general consensus from his clients anyway is that, the florist part or the coffee shop is okay. The garden center is generally okay. It's really all about the event space and what conditions can be placed on that, and to some extent the garden center as well. So I have a pretty long list of proposed conditions that I think we should discuss, and there may be others. So
Mr. Rosenbach, do you have the copy of this proposed conditions?
I was given a copy a few weeks ago. I don't know if it's current or not.
We have an extra one.
Okay, great, thank you.
And if anybody else, member of the public, wants one, we have several extras here.
Mr. Chairman, can I just ask, and Mr. Oler too, as well, just as a point of procedure, if we're discussing conditions now that might be imposed upon this applicant's application,
right?
It's board and applicant. I don't want Mr. Rosenbach to assume he's got an active role in this part of the process at all. My position is he certainly does not.
Okay, but on the other hand, he should have a copy of what's going to be discussed.
Absolutely.
And Mr. Oler,
and I think this is a discussion for the board right now, right? The case has been turned over to the dais, right? And if the board has a question of you or Mr. Rosenbach, they can certainly ask it, but basically this is a board discussion.
I agree. There might be conditions that the applicant might need finesse, Mr. Oler. So in that regard, I would just, chime in when there's an opportunity when we get to one of those items where the applicant is looking for some discussion on evolving a condition, perhaps.
I'm quite aware that I'm not part of the board discussion.
Okay, thank you.
Okay, so in no particular order, really.
Let's start up
I prepared this list of conditions, just kind of following along through the hearing notes. So number one was that there be no outdoor events shall take place on the South Street front yard lawn area. All right, and we can take these one at a time. If you have any questions, I think we should just address them as they come up. Right. Two is outdoor events shall only be permitted on the paver courtyard and the greenhouse. Hours of operation shall be the florist and home decor business, 10 a.m. to 6 p.m. Coffee shop, 7 a.m. to 4 p.m. The garden center, 7 a.m. to 6 p.m. The event space would have a 10 p.m. curfew. Right.
So, is the board members, any questions on those?
Yeah.
Yeah, what?
First one, no outdoor events in the front yard. So if they decide to have a wedding, they want to have pictures taken out there, that's not permissible by this? I think we're getting a little too nitty gritty. Just want to make sure that what we're proposing encompasses everything that might be an issue.
Right.
And that doesn't include things that really aren't an issue.
That's fine. I mean, that came up at like the first hearing, right? So it was in my notes and I'm just listing everything that was discussed at the time. We could qualify that to say no group event. I thought the intent of that was that there would be no group of people at that.
It wouldn't be the center.
I think that the better one would honestly just be the second, just do number 2. Outdoor events shall only be permitted in the center, basically the center of the site. Because I think that, when you're talking about someone taking a photograph or something like that, like that's not where that event is taking place.
Right.
And I think so I think that that's a good point. And I think that we do, but again, this comes down to enforcement, but I think that we want to be, where we can, I think we want to be specific in the affirmative rather than in the negative. In this thing. So, outdoor events shall be permitted in the, and maybe we can even have like somebody that shows it or something like that, but I think
the acoustic engineer had where he located potential, and nothing was in the technical front yard. Everything was in the body of the property, if you will. Yeah.
Yes, because I think that they, I think we want to keep this. It's not going to be simple, but I think we want to keep it as simple as we can and not duplicate or contradict any of the conditions.
Scratch 1, keep 2.
That would be my suggestion.
Okay. All right, and then the hours of operation, anything there?
There was some mention of 9 p.m. at one point.
Yeah, there was today.
The comment that was said, and I can't remember who that came from. Oh, I guess it came from one of the members of the public speaking, was that she was told that the applicant had said that the events have to end by 9 so they can be totally shut down by 10.
So that's in line with the applicant's proposal for outdoor events. The applicant's proposal for outdoor events is amplified events, particularly on the heels of that acoustic study, and they would cease by 9 p.m. is the plan. And they are certainly not going to be year-round, 365 days a year, the outdoor events.
Yes.
So outside events would terminate at 9 and indoor events at 10?
Yes, sir.
Yes. And I think that a lot of this goes back to the fact that some of these conditions do date back to earlier in these proceedings. I would recommend, that any of the retail coffee portion of the site, 7 a.m. to 6 p.m., outdoor events 9 p.m., indoor events 10 p.m.
Right.
If that's acceptable, just to streamline it. Just to streamline
I'm sorry,
it.
give me that again.
I was just going to say, if you kind of combine the florist, home decor, garden center, coffee shop, retail sales, 7 a.m. to 6 p.m.
Okay, so they have some flexibility there.
Yeah, and that way,
They can close it at 4 if they
and
want.
what if one cash register is using something for the other? You know what I mean? So they can close earlier, they can open later, but 7 to 6 would be what that would be for retail sales and garden supply. Outdoor events, 9 p.m. curfew, indoor events, 10 p.m.
Board members in agreement with all on that?
Yeah, I mean, I guess the only point of clarification, maybe it's not apparent to me, but you could have a hybrid event where it's like outdoors and then you're coming indoors, right? It could be the same event, just has to move it inside at 10 p.m., right? So there's
No, inside at 9 p.m.
Inside at 9 p.m. to
Yeah.
continue on till 10 p.m.
Yeah,
inside.
I would assume, I mean,
Okay,
again, just
yeah.
what their operations are, but typically you'd think that it would be something that you would move it in earlier than that because it's
Right.
a little late in the night, but yes, that they could
Okay.
technically do that, yes.
Okay, number 4, the applicant indicated they would repave Pear Street. They would need township committee approval to do that, so they'd have to apply for that.
That's fine.
We could, just on that topic, there's, well, you know what, let's get through all the Pear Street stuff and then I'll discuss it, because there's potentials of other vacations and other things, license agreements. So we'll discuss them all in whole.
Okay.
Yeah,
So-
I would kind of categorize these under the,
Street
conditions that
improvements.
involve township committee or municipal approval. Kind of look at those as one bucket.
Right. So the next one then is the applicant shall apply for township committee approval to retain the fence located within the Pear Street right-of-way or relocate the fence to a permitted location. If required by the township, the applicant shall enter into a license agreement with the municipality for the use of the existing on-street parking spaces along Pear Street.
Correct.
You want to jump in there?
Yes. So in totality, everything that's in Pear Street is part of a paper street right away. And and the road has been maintained by the municipality historically. That I don't believe the road was originally constructed to our current municipal standards. So I think it's a substandard road. But it provides sufficient ingress and egress to the site as well as to 2 residential properties on Pear Street. As you transition past what used to be the old utility building,
Right.
and you go past that last driveway of residential, access is exclusive to this property. I would recommend the applicant seek the vacation of the right of way
Beyond
to the west of the last driveway, which is, it is address 8 Pear Street. West of that driveway where the access is essentially a public paper street without the correct improvements for us to accept. Right. So in lieu of improving it for us to be able to accept the on-street parking and the aisle in that area, I think it's more beneficial to all parties that the applicant seek it being vacated.
Okay.
So it would be to amend this to include a recommendation that they seek the road to be vacated west of 8 Pear Street driveway. And in lieu of that, the license agreement is the alternative.
I have a question, Joe. What, if that were to be vacated, if it were to become part of their property, wouldn't that change some of the technical aspects of this application?
In terms
Like
of coverage.
coverage or landscaping?
As, I think as
things like
filed,
that?
I don't think as filed it does. I think as because the action would be after this board's action. It would be,
Okay.
right? It would be a vacation of the area that would not be in whole to the applicant's property.
Okay.
It may also be to, say, 22 Prospect on the opposite side at half width, and then private easements would be secured between them.
What happens if they can't get those easements and?
Then it goes to the license agreement option with the municipality. That's already stated.
Okay.
There's no purpose for the municipality to hold that road as a public road.
Right.
Yeah. And for that on-street parking, that could become on-site parking as part of their calculus of their parking available to them.
Right.
So essentially, the driveway starts as you pass that original utility building, and then on the opposite side, that emergency access going out the other side starts at their driveway as well. Everything else is interior to a site.
Okay.
So it's the alternatives of the mechanism to vacate Pear Street or obtain the appropriate license agreements.
Right.
For those areas that were improved.
Got it. Okay, continuing on, the two-story frame dwelling may only be used as a caretaker residence and may not be separately rented to a third party. No power equipment shall be used on site prior to 9 a.m. There was some discussion about only using electric blowers on the property.
Can I offer something there, Rich, on that
Yeah.
real quick? And the caretaker issue is fine. The applicant already stipulated that one. The applicant does use electric blowers. Before 9 a.m. is certainly fine. They don't need to fire anything up before 9 a.m. They use electric blowers. They do have commercial landscaping services on this property once a week where their landscaper comes out once a week. The landscapers often throw on gas-fired backpack blowers. So if the condition, we're amenable to a condition that says electric blowers, but if we could tailor it to the applicant's use, because we really can't control our landscapers right now. Maybe one day the ordinance catches up and it does. But what the applicant's concern is we know we've got neighbors, few, but neighbors who are always paying attention to us. The applicant's not interested in the PD being called every single time you hear a gas blower, and it turns out it was, Mike's Landscaping Company, and it wasn't South Street Gardens. So that's the only issue with that prospective language the applicant would offer.
Can council wait to comment until we're done discussing the particular line item?
I can't. Rich has 20-something items. I don't know if he wants to go through.
I know.
Going. So
I was just gonna
we
say,
certainly can.
the township allows gas blowers. Until they don't allow it, I don't think this restriction should be put on them.
Well, the thing is, it's a commercial property in a residential zone. So, and it's a garden center, so there could be a opportunity for lots of gas blowers. We all get annoyed by gas blowers, especially in the fall. But putting a requirement for the property owner to use electric blowers. Electric blowers are so much quieter.
No, they're not. I own both. They're really, there's very little.
I own a gas electric blower, and I can be running mine, and I can hear the gas blower way down the street. So I think your suggestion is probably preferable. If you got people, an outside contractor on there using gas blowers, acceptable until township bans it, but your people will just use the electric.
And how are you gonna police that? You know what I'm saying?
I understand that. Yeah, I understand, but at some point, you've got to trust them to do something. And it's better to have it there than not put it there and just say it's going to be impossible to enforce.
Yeah, Mr. Schuster, I'm always here saying, enforceability, but I think that the idea that this is a business that could use blowers as part of their hourly, daily operations, that's the distinction here. Once a week, whatever, they come by, that you could do in a residential zone, that I think that you're right on that point. But I think that's where the noise actually can have an impact.
Yeah, because they're going to be blowing pathways and everything else in the patio regularly.
Okay.
And just a question on the no power equipment, because again, how do we, enforce all this, right? They may have a backup generator, the power may go out, and there may be power equipment running at 8 a.m. to keep the plants alive or whatever they may have. And then, we want to prevent situations where the neighbors are calling saying, I hear power equipment running or what have you, because nothing before 9. So I just don't know how granular we need to get with this, and I'll defer to the professionals on that, or any thoughts?
I think obviously what we've heard throughout the hearings, and especially tonight, is that, the noise element of this business is of concern to a lot of neighbors. So this is just one other way to try and keep the overall noise level down.
And I think, some even say except in case of emergency.
Right.
Because, unfortunately, if there's a power outage, it might be the whole neighborhood, something like that. So
Right.
that would, something, yeah.
I just don't know how granular, we do need to get at some levels, but.
Mr. Kelly, when the contract landscapers come, that's not going to be before that. I know, you can kind of control that, not always, but.
They typically come, it's a weekday. They typically come right now on Mondays. It's typically morning.
I mean, that's not something we've heard complaints about. I will say. I think we don't want there to be complaints, but it's you having experienced it, you don't want the landscapers coming at 7:45 a.m. if you're have been at a hearing late the night before. But yes, I think that, that's kind of been that whole threshold of the night.
Are you okay with the 8 a.m. or 9 a.m. rather?
We can definitely live with 8 with our landscaper. I don't know how much earlier we can control them. We can try for 9, but
Let's go with
9 or 8?
I'd go with 9.
9?
I know, wait a minute, what's the township ordinance on 8 a.m.? Is 8.
8.
Township ordinance is 8, so should we do 8?
we really can't control the landscapers.
Right, I
We can
understand.
nudge them, but we can't guarantee it.
Right.
So we would say 8 for them, 9 for us. We're fine with what we can control being at 9 a.m.
Board members, any thought on that?
Stay with, keep it simple. Town ordinance is 8.
Stay with the ordinance, right?
Right.
Yeah. Okay. All right, and then indoor and outdoor events will be limited to the following types of events: floral design and gardening workshops, wreath making, butterfly and terrarium workshops. I think this list came from the applicant.
Yes, I would recommend simplifying this.
Yeah. Go ahead. Do you want to hear them all, or you want to simplify it?
No,
first?
just get rid of
I
A
would-
through J.
I mean, I would state this as, events on site shall be limited to, instructional sessions, workshops, and classes related to things sold on the site, weddings and similar weddings, showers, similar parties, up to maximum occupancy of 48 people. Get rid of D, get rid of B, get rid of E. F, I would just say private parties, fundraisers, or corporate events. Other private parties, fundraisers, or corporate events up to 48 people for the event space. The problem though is that doesn't address the outside. You know what I mean, where it has the maximum capacity. So maybe because I think that maybe we even take out the permitted occupancy, because that's part of the code. They're not allowed
Right.
to go over permitted occupancy.
Right. Which is 48.
48. That's within here, yes.
And those are humans, right? They're not just party goers, it's staff also that's working the parties.
It's 48
Seats.
48 guests.
Seats.
Okay, I just wanted
Yeah.
to clarify
Which is
that.
how we laid out the seating. So the volume of that room could handle a higher occupancy under fire code, but 48 is what the applicant said.
Gotcha.
We're not going over this amount. That's our max. We need to lay this out comfortably. So
Okay.
48 was the number they landed at with design.
Great, okay,
For
and yes,
indoor
that would
events.
be 48 guests.
Okay.
Right. Indoor.
We are either allowing an event space to happen or not. I don't believe that we should be dictating what types of events there are. What if there's an event that isn't listed in this? I just think we're getting too granular on this.
Right.
Okay?
Fair enough, yeah, and as Mr. Oler said, this list did initially come from the applicant, so I think that's the framework we were working with.
Yeah.
We were worried about that too, Mr. Schuster, because at what point are you not quite in G, but you might be, and who's orbiting that, right? That would be an enforcement issue. I think that the terms the private parties, corporate events, and fundraisers, those are very large shotgun blast, I think, types of phrases. So I think that we as an applicant team are covered, because my client said to me, what about X event? What about Y event? Well, that's a private party as we see it. So I think that does give us the rubric of cover there. But I agree with you, when you start getting too granular, it becomes a mess.
Okay. Food trucks shall be permitted in conjunction with permitted events on a temporary basis. Applicant shall obtain any required health department permits for each event in which a food truck is used. There shall only be, and then again, we started throwing numbers around, 1 food truck per event permitted.
This is to confirm that from the last hearing,
Right.
permanent food truck is no longer part of this application.
This is a good time to bring that up. So the applicant is fine with that condition. I think 9H, it's written as right there, Rich.
Yeah.
But if the board votes favorably, the applicant does have a request that semi-permanent food truck that the board has seen there now, it only operates till 3 p.m., but it's out there now. The board asks that can remain until there's a CO in place for the cafe. And then at that time, the food truck will proceed under 9H. Permitted in conjunction with the events. And the reason being, that gives the applicant a runway for their business. The food truck is doing very well right now. The community seems to love it. It's not impacting anybody in a negative manner. It closes timely. It's not creating any noxious realities.
When's it closing right now?
3 p.m.
Oh, yeah.
3 p.m. So when there's a CO for that cafe, that's when the applicant will gladly pivot to those operations there for that, that light fare. And then the food trucks will come in on a permitted basis. They'll apply for the permits as they need to when they're having their events.
To me, the distinction, I think that that's fair, I'll defer to the board on that, and then the event food trucks are a different story. That's just
Right.
a couple hours. And that obviously would have to be, because as we learned last time, there isn't really anything in the township code that disprohibits it. But I think that the permanent one, once the cafe is open, that's when your scope starts to get a little more than what we ever thought we were.
Do we want to put a limit on the number of food trucks? And what is that limit for an event?
I just, my take on this is that just the size of the site, the number of people that are limited to the events, I think that's gonna self-police. Someone's not gonna wanna pay for, 3 food trucks that aren't gonna get used or something like that.
For 50 people.
Yeah.
Well, right, so how many do you think? 1, 2?
Again?
I'd say that loud.
2.
It's a big world out there.
I think
and there are food festivals.
we're getting into the nitty gritty.
But not for 50 people.
Yeah, right. Well, they wouldn't necessarily need an event space for they don't have to use, you could advertise it as a food truck festival and bring in 12 food trucks, and then they could shop and do whatever they want, not necessarily have to use the event space.
So let's limit it to 2? What do you think?
Just before that, the discussion, right, where they are located on site.
Right.
Because like we were just saying about it self-polices itself. If they're going into courtyards, there's only so much space to functionally put a food truck and then have people congregating around it in an outdoor event.
Right.
Right. So if they were to be designated in an area in the parking lot, I don't think that's ideal. I think it's more ideal probably that they're in the courtyard or in what's currently like the on-street parking area.
Right.
Parked end to end there, using up that space so everybody is then walking across to that area. But I think of those spaces where you would put them, where they would be put for an event, when you're thinking of how many you would like to have on the site, or if you're restricting it at all.
Well, another thing is that you don't want the food truck taking up off-street parking spaces that are part of the site. So I think that would be, I would offer that. Or anything, no events, even something, sorry, we're getting a little creative. But you don't want it to take up off-street parking.
Yeah. If there's a food truck there now, you have some experience with that, where is it?
It's right in the entranceway.
So some,
Previously just went witness, so why don't you answer?
So it's immediately west of the proposed coffee shop, tucked in next to the building and surrounded by plant material.
Yeah.
So it's not in the road.
Exactly.
As Mr. Bruce mentioned, it's not in the parking stalls, a really good spot.
Yeah, and what we could gladly do is work out a detail with Mr. Vuccio, effectively a staging detail, that here's where the food trucks are gonna be, Joe, if and when we have events down the road. We're glad to supplement that and file that as a post-approval resolution compliance item. And then it might be self-policing. You might not fit multiple trucks. It might be cost prohibitive for an event to say, I want it catered by 2 different purveyors. So I'm not certain we need to regulate the quantity. It's certainly not going to be 10 out there, but is it likely to be more than 1? Maybe not, but could it be?
right, but we don't want like a food truck gala.
Oh, I understand.
I think comfortably in the location that it's at now, which is on the side of the courtyard.
Right.
Right. You could squeeze 2 in there side by side.
And that would be about it.
And then from there, there's not really another spot in the courtyard that's convenient to put them.
Right.
If there were more, I think 2 in courtyard, and then the others, if they were to do it, I think would be naturally in that on-street.
I'd like to limit the number.
Just keep it at 2.
I
We
think
got
so.
2 more
I
of
think
these to
it's
go.
appropriate.
We got to keep it at 2?
Yeah, and we have 4 minutes left, so.
Okay. Keep it at 2.
2.
Does everybody agree on that?
I'd like to vote on this.
Okay.
Okay. So then this one, which may need more discussion here, is about the outdoor music, right? So indoor and outdoor music in connection with permitted events may take place, except that any outdoor music shall not be amplified, and no speakers or microphones shall be used with any outdoor events. And then at the last hearing, the applicant spoke about limited amplification by providing some amplifiers that would have governors on them of some sort.
Yeah, so the applicant's request is, to be clear, they would like amplified music outside. They think that's supported by the expert testimony in the record from the acoustic engineer and the applicant, and it was brought up as a discussion point, I think perhaps from Mr. Booch, was, well, can you control the equipment? The applicant said, yes, we can control the equipment. Can you control the equipment in a way where you're managing it with a regulator or a governor where it can't go above a certain volume? So there can't be that oops moment, and we're not getting a call saying lower it, oh, we'll lower it, sorry, it won't happen next. Yes, this can be completely controlled on the front end before there's any incident proactively. It would be equipment that would be controlled by the applicant. I don't know if they would actually be the ones that actually own title to the equipment or not. I'm not sure what this costs, but the equipment would be controlled by them. Remember, the applicant is at every event. They're running every event. The caretaker lives on the site. The outdoor events will have a shut-off time. The speaker placement during that acoustic test was such that it tried to boom in every direction, the acoustic, and it complied in every direction. So the events are in the body of the property. Yeah, Mr. Chair.
Yeah, I'm just saying, like, the fact that it complies is not the be-all, end-all, because they're asking for a variance to put this property in, these events in there.
I understand. That's why.
So that's why, I'm concerned about the neighbors. It's one thing if, somebody in a residential neighborhood has a party, once or twice a year, as opposed to a regularly scheduled events taking place outdoors, and the people down the street are saying, I hear this 4 nights a week, I hear this 3 nights a week, because they don't know exactly how often this is going to occur. But they're going to want their windows open, on a nice evening, and they don't want it all coming in.
I understand.
So I'm like in favor of not having acoustic music outside.
So I'll just
Amplified.
I will just
I'm sorry.
recast, because this is important to the applicant. So here's what we're proffering for. It's amplified music outside. The applicant is willing to have an earlier shut-off time of 9 p.m. as opposed to 10. It does comply with the acoustic measurements. I realize that doesn't get the whole warm and fuzzy, Mr. Chairman, but it does comply, right? To be clear, it does comply. And the applicant is not intent on doing this year-round. There's going to be seasons where it's completely incapable.
I understand that.
The applicant has talked about an average of, no more than an average of 1 a week. Just to put a number on it, there's 365 days a year. There's not going to be 365 outdoor events a year. The applicant said, if we're averaging 1 a week, that's 52 a year. So that is a cap that you're likely looking at. I suspect it'll come in remarkably lower than that, outdoor events, because they're going to want to use that beautiful indoor space as well. And again, the applicant's not proposing Animal House out here. They've got amplified music playing out there today in the garden center as you're walking around.
Oh, the ambient music, they can't.
It's ambient.
I understand.
It's ambient and it's not heard on off the property line.
I understand, but it is amplified music.
So we can say ambient music is allowed so long as it's not heard beyond the property lines.
So the applicant's proposal for the outdoor event space is for events to be amplified at their election. They may not all be, but it will be amplified. The outdoor events will shut down by 9 p.m. And the cap effectively is 52 a year, no more than an average. They're averaging less than one a week or less on the average.
And how do we? Yes.
I want to point out, I'm going to remind you of what the sound engineer who did the tests.
Yeah.
I don't have the exact number here, but it was 50 to 60 decibels at the property line, and it was only a couple of decibels above Route 287. That's in the report. That's what the sound engineer measured. It's barely above 287 with amplified music. I'm only going to throw that one out there. You could hear it at the property line at about, I think it was 2 or 3 decibels. Anybody else remember that?
I remember.
Yeah.
Okay. I think that's a really important point. Barely above 287.
287's loud.
Well, but when you say it's barely above 287, you're barely hearing this above. I mean, there's a lot of noise already there.
Right.
But they built sound walls around 287.
Not there.
But every place else. I mean,
Amplified music is the biggest sticking point to the people that are against this. Okay,
Yes, that's true.
And I think that needs to be heard.
Yeah, I
Not
agree
like
with you on that.
amplified music. I don't think there
I
should be
agree with
amplified
that.
music outside
I agree with that.
pertaining to events. Okay.
These people have spent months and months. I appreciate their attendance and participation. And they have really guided this application to where it is now. And I think the noise, particularly for the local neighborhood, it's a real critical issue. I would be in favor of no amplified music outside.
Concur.
Yep.
Okay. Again, everything else.
Okay.
I can't see that. Sorry.
All right, 10 was the event space shop. I think we talked about it already.
Yep.
Maximum 48 seats. All activities on site would cease no later than 10 PM. Again, the outside was concluded by 9 PM.
Because we already have it in the, we captured that.
We captured that in the earlier ones. Okay. All permitted events shall be staffed and monitored by the applicant or its successors. There shall be no third-party rentals of any space on the site. Use of any alcohol shall be subject to the approval of the
Let's go back to that staff. They don't, permitted events, they don't have to be staffed by them. They'll have somebody on site, but they could bring, bring in caterers from the outside because that's part of being staffed. So it's just like they're going to have somebody
Staff
on
is just a
site.
terminology that someone from the property or ownership will be there. That's all
Right.
it is.
I would recommend combining that with the, this, like, it's like two or three down about no subletting the space and one operator. I think that's all one condition. I think it's very clear, especially if you combine those two, it's very clear what that's intended to state.
Okay, so we're omitting staffed and just saying monitored by applicant as well?
I think staffed is fine. Is that what we were saying?
Yeah.
Monitor.
Okay. Use of alcohol subject to approval by the Township Police Department and the Alcohol Beverage Control Board. No food shall be prepared or cooked on site, although food may be reheated on site. The kitchen shall only be a warming kitchen. No meals or food of any kind shall be served outdoors.
Well, wait a minute, we got a food
Wait,
truck.
you got a food
Right,
truck,
so
now,
it's gotta
so
go.
that's different, right?
I think we can just skip that one.
Yeah.
There's not going to be formal seating,
Yep.
so yes.
Uh,
For number 16, I believe the applicant submitted a detail of a dumpster enclosure. with-
So we already have it on the plan?
So we already have that.
Okay.
yes. It's dated, it's from last summer, but yes, so that's.
Okay, the applicant would comply with all directional requirements of the board's traffic engineer. There should be,
That's on the phone.
August 5th.
okay. Again, we talked about 18 would jump up and become part of 12, but there'd be no subletting of any space or uses on the site, right? All uses on a site shall be conducted by one operator. The proposed signage shall only have externally grounded mounted low voltage lighting.
That's already on the plan too.
Yeah,
Okay.
I agree with that. I think, the applicant has to abide by what's on the plan if they're
Yep.
going to get a permit without it, so.
Okay, there should be no outdoor signage or advertising of the coffee shop. All site lighting shall be downshielded to avoid light spillage off-site. Is that a plan detail already?
I don't know if it was or not, but they agreed to it.
I think
Leave
that's,
that in.
leave that in.
Okay.
Comply the way, so you have.
Because there might be lighting that's not new or something like that.
Okay.
Keep that in.
Had
Does
a
that
blink
include
one-
dark sky?
Yeah, it had dark sky separately later
thought
because it
so,
came up
okay.
later, but that would be part of that same condition, be dark sky compliant. I had a blank one in terms of deliveries being made Monday to Saturday, but the hours,
7/7, please.
7 to 7. Board okay with 7 a.m., 7 p.m. on deliveries?
Yes.
Remove all the debris from the wetlands area to the satisfaction of the township engineer and obtain any required permits prior to removal. Joe, is that all right?
Yes.
23.
Okay.
24, no landscape materials, including bulk quantities of mulch, soil, stone, wood chips shall be stored on site, and no such items shall be delivered by the applicant to any third parties.
Rich, can we stop at that one for
Yep.
a moment, please?
Yeah.
Thank you. So the applicant does have material stored on site. It's for their own use as they need it. So material comes in, they've got a pile of topsoil, they put it down to keep the, to
Right.
keep the material. They don't sell in bulk. You're not coming out with your own company, going over to a bin with a bucket loader or a bobcat, lifting it up, putting it in
Right.
the back of your truck, scooping it. So there is some outdoor storage.
Okay.
These sales are retail, retail. You're coming in, you're grabbing a bag, you're grabbing a 20-pound
Yeah.
bag of material, you're walking out. But there is some on-site storage of materials. for use by South Street Gardens,
But not for delivery.
So it's,
but not for delivery.
so it's like, it's no sale of bulk materials.
No sale.
No one's
No,
buying,
there's no wholesale.
but no one's buying, 5 cubic yards of soil.
No, that's right.
Yeah.
Landscapers aren't coming, getting, enough
Right.
to do someone's entire front yard bed, for that
Right.
spring or something like that, right?
And is that area designated on the plan?
For where the,
I think it is.
I don't know if it's on Fred Stewart's plan. We certainly can locate it to the satisfaction of Mr. Vooch.
sounds
It's a
good.
small area material. It's not like you're talking about a contractor's yard where you've got the gravel here, the pea gravel here, or the aggregate there and the topsoil here.
Rich, I think from the condition standpoint, what do you think? The idea is that it's coming on the site via a delivery,
Mhm.
and that's it. No other trucks are coming to
Right,
pick it up.
it's just not for
leaving
delivery.
Via truck, yeah.
Yeah, I'm just going to change that to say it could be on site, just not for delivery. Right.
Bulk or delivery to. Or sale.
Sale.
They said they're gonna bag it up and sell it, which is fine, yeah.
Okay.
I'm sorry, again, I'm not trying to delay things, but I just want to be clear for the purposes of the public and the noise and stuff in the neighborhood. So if deliveries, you have some large shrubs, some large trees, if you're having deliveries of material at 7 a.m., is it all manual offload? Like, are you going to be using a forklift or anything to take that off of the truck and making noise at that early in the morning? I'm just trying to sort of protect, what we're trying to preserve.
Does the landscaping come from from the applicant's own supply, or?
No,
Okay.
no. They try to stagger deliveries, so at 7 a.m. you're not going to hear a lot of beeping typically, but 7 to 7 is the window they need for deliveries because they in fact do stagger them.
Okay. Again, okay, thank you for clarifying.
Okay, 25 would become part of what we've already talked about, right? Dark sky compliant on the lighting. 26, the monument sign shall not be a digital sign, and may not be internally illuminated. I think we already talked a little bit about the
Yeah,
sign
Yes.
before.
That's covered.
Yeah,
Just so you know, that plan is already as an exhibit from months and months ago.
Right.
Ground lighting's confirmed, no internal illumination is
okay.
confirmed.
The applicant shall apply for township committee approval to retain the landscaping existing within the township right-of-way and any additional landscaping proposed to be planted within the township right-of-way. This is going to go back to whether there's a vacation or not.
Yeah, that's
too,
going to
right?
get assumed in
Yeah.
the same all-in-one comment
Right,
and condition.
right. And if that's not approved by the township committee, they may require its removal. I mean, what's going to be in their ballpark?
Yeah, it's going to be one or the other.
Yep.
Right, vacation or license agreement.
Yep. Okay. And then some of these are a little more standard. Would comply with our health department letter from February of 25, comply with the ongoing health department requirements, comply with environmental commission's report from March of 25, obtain Morris County Planning Board approval, and comply with all other township agency requirements.
Those are fine. Can we revisit the outdoor amplification for a moment? The applicant made a comment to me that perhaps the board would consider as.
Sure.
Thank you, Mr. Chairman. It's a big component of what the applicant is hopeful to do, as the board knows. We understand, we've heard several board members, certainly a majority of them, say there's a concern with the outdoor amplification. Would the board perhaps be amenable to fashioning some sort of a condition that does allow the applicant to apply on a special basis for outdoor event permits up to X number of times per year? As opposed to the carte blanche of any day we want to go out there and have an outdoor event because we've sourced a client to come up to the property and have an outdoor event, which, like I said, could have been up to 52 times a year. Is the board amenable to us doing this on a more of a special basis for an outdoor event? Regulated either in quantity or by time of year. We would say quantity might just be the simpler one, but the applicant keeps coming back to this, Mr. Chairman, for a reason, and they're certainly amenable to working with the board to get the comfort level there, but something is better than nothing, and the something is not a very big ask with what they're asking for, a number you can probably count on a couple of hands.
Is there, and I guess I don't know if this question is for Joe, is there an existing township kind of system in place for that? Because otherwise, that's kind of a
For
burden.
special event.
Yeah, it's kind of a burden to kind of create something new just for this site.
Right.
You know, and I don't, you know, I think I understand what Mr. Kelly's asking, and I think it makes sense in somewhat, but I just don't know how real, you know, like, will that involve going to the TC every time, you know, or like, what exactly?
Well, yeah, who's the approval mechanism?
Yeah, exactly.
I understand there's a township committee special event approval.
So it'd have to go to the township.
Carnivals, fairs, block parties, or the like, which has which is noted in our noise chapter 345 as an exemption for special events. Approvals by the township committee of a special event such as a carnival, fair, block party, or the like shall be deemed to confer an exemption from the strict requirements of this chapter. The township reserves the right upon short notice to withdraw the exemption conferred in this section. So I think the intent there is if there's a special event permit requested from the governing body and they provide that approval, then it's governed by the bounds of how they've prescribed the event. The date and time, you know, the nature of.
So that would be, it's not us giving that approval, it would be the township committee giving that approval. Even if we said no outside events, they could still proceed it.
No.
So perhaps just the way to phrase it would be that if there are outdoor events that are permitted in this use approval, the amplification of music can be added to a special event request of the governing body, right? So you're not excluding the amplification of music, you're deferring it to the governing body as a special event on the property, as opposed to one of their curated events.
So I agree, Joe. I'm going to make it a little, like, I think, like, the way I look at this is again, this is a D1 use variance that they're asking for to have these events here. And I don't know, you know, this is not a zoning chapter. Like, you know, what with this, but I think what we would want to do would maybe be something following the procedures of that chapter. It would not mean that they were able to violate the noise ordinance, because that's what that's saying, because that's talking about like big events. And I don't think that's what you're asking.
No, it's not. We're asking for, you know, we have up to 10, 12 a year. So, you know.
So that's going to be my next question. But I think that there is a procedure in place. And it again, this does get complicated. But for the board, this is a D1 use variance, and you have the right to control that. If you say no outdoor amplification of music, they cannot go to the township committee and ask for an event permit.
Right, and that's the concern with the total preclusion is very tough for the applicant. We're fine with it not being infinite. We're fine with it being a finite established number in a resolution of approval, but that's what we're asking the board to consider, is a finite number of outdoor amplified events concluding by 9 p.m.
So that the outdoor event is part of the contemplation of the D1 use approval, and then be deferring their request for.
There would have to be a special condition saying.
So the event can happen under the use, the wedding, indoor, outdoor on the property, and if that particular client wishes to have outdoor music, they could work with the applicant and make a request for a special event permit from the governing body to allow music, or we just move on from it. It's not part of the discussion.
It would not. This board's role would be to decide if that is something you'd be willing to consider and have that in the resolution. And look, I mean,
or if it's a hard line on the D1 use variance without it.
Yeah, without it. It would be a special, you'd be approving it with no, and then you can either approve it with no outdoor amplification of music. You can say the applicant may request a special event permit for up to 5 to 10, whatever number they throw out from the TC, but also from the governing body. But that doesn't, which also that doesn't mean you're going to get it every time.
Right, that's right. It's just that this zoning board does not shut the door on that opportunity up to a certain number. That's essentially the ask. It's belt and suspenders. It's not a guarantee it's even going to happen.
Up to 10 events can be requested for amplified music as a special event from the municipality.
And I think that it's more work for the governing body, but they would have to put together a plan for special events. You would have to, you're not going to have to bring an acoustic expert every time, but you're going to have to, put together what that would look like. So it is an extra layer of protection on the applicant if the board is interested in allowing that. That's it. So my question was just if there was a procedure in place, which there is, So that would, I think you could kind of defer back to
The
that.
special, my understanding of our code, the special event permit process is not prescribed in our code. It's afforded, it's referenced in the noise section. So I can't speak to when somebody wishes to have a block party, how they procure that through the clerk's office
Right.
and what's part of that application. I can't speak to that. I'm not familiar with that yet. But there is a process for getting that approval from the TC.
Exactly, exactly. I didn't want us to be making up some new process. That was too complicated.
I'd like to hear what the board members think. I'm still in favor of the no amplified music outside. I think it makes it very simple.
Yep.
And I
And
think,
so am I, but the question here becomes, do we approve the ability of the applicant to have events up until 9 o'clock outside? And then if they want to go to the township committee for the amplification of sound, that's a separate thing. We're only saying you can have the event without sound unless you can get sound from the township committee, if I understand.
and we can limit that number of times they can do that per year.
Right, so you
Right.
say no amplified music without a further permittage from the township committee.
Yeah.
Or go inside.
And limited to X number of times per year.
5 times a year?
He had said 50 times a year, so I.
Well,
No, he
I'll
said
say
50 events, but he said for
My
music.
number kept going up. I was looking at the faces in the room. I started at 5, and I get a flinch, I went to 10.
I heard
I think, look, I like to go numerically, like 52 is the weeks, 12 is one per month. I mean, 10 to 12, we think, and it's an up to. It's a ceiling. It's
Once
not
a quarter, 4.
Once a year,
That's a lower
one.
number than mine.
Uh,
I mean, once a month seems reasonable.
But, you know, they're not going to be holding them in January, February.
Well, that's the problem, because in June they're going to want to have 4.
Yeah, so 6. I know it's not a 5 or a 10, but
I like
I'm
the
still
10.
inclined just to have no amplified music and keep it simple, but that's just my,
that's your,
that's my, yeah.
Andy, what do you
That's
think?
my opinion.
I would be open to I would think 10. I would be open to 10.
Darnell?
I think that they should be able to have their music. I think that we can monitor it. We'll put a limit on it. And I'm okay with 10. I'm okay with 10.
10? 10. Far end of the. What's
I don't like it.
What?
I've been an event planner for 35 years, okay? If you have an event for 50 people, you don't need amplified music. You don't.
Right.
You want to do it inside.
Yep.
You know what? I would agree to amplified vocals, but not instruments. But again, how do you police it? I don't want the neighbors calling, the police department every time something goes on.
We will. Well, that's what's going to happen, right? That's their only mechanism.
I know.
Right, is to say, hey, they have amplified music, it's louder than the ordinance permits, and 911.
And the guy who runs the equipment isn't on duty, so there's no, because it's going to be at 9 o'clock at night, and if the guy's not on duty, they can't enforce it. Because not all officers are trained to run that equipment. There's usually about 2 or 3.
He makes a good point. For 35 people, they need amplified music.
That's what I'm saying. I'd rather go with no amplified.
No amplified, that's fine with me.
Because you already have the ambient music that's permitted during all the use.
Right.
Yes, and we can write that into the resolution.
Right, so the ambient music that can
that's
play
fine.
throughout the facility in various events is just ambiance.
Right. Okay. Let's move on.
I think that was all of them. We went back to this one.
Right.
Motion adjourned?
No, not yet. Okay, so, members of the board, now that we've put all these conditions in place, we have to discuss whether we wish to approve this application and why.
And as I would suggest we have a motion, right, in the second, and then the reasons for how you would vote should be explicitly put on the record.
Okay, so do I have a motion?
I'll make a motion, Mr. Chair, that this application be approved. I think that as the world changes, the use has to change with this property. I think that it's a better than its current, what it used to be. Its current use is basically, it was a blighted piece of property in Morris Township. I think that we should be moving in the right direction. The uses change, things develop new avenues, and I think we should approve this application given the current conditions that we have.
With the current conditions as we discussed.
Yes.
I'll second that.
All right. So why don't somebody start off saying why they would like to approve this application?
Sure. I think this is a great item that's being brought to the township. I love the fact that it's multi-use. I think it's an opportunity for a garden center that might not actually be as successful as it would be without these other elements. I think it's great for the community. The look of the space is fantastic. They do a beautiful job. I think it'll be an asset to our town, and I look forward to continuing to enjoy that. I've been there a couple of times. They're great people. They offer a great service, and I hope that we can pass this and welcome them to our town officially.
I think that with these conditions in place, and I want to again thank the members of the public for coming out because you really helped define the end product here. With the conditions in place, I think that the positive attributes outweigh the negative. Very concerned with the negatives because of the neighborhood. The positives are the reuse of a piece of property that was formerly a garden center and will continue to be a garden center, and will use the property in a community-centric fashion. Some people have said it could be very well be 25 townhomes. I think that with the right conditions in place, it won't be invasive to the neighborhoods, but it'll provide community areas for people to go and a shopping center for flowers and stuff for the community. And I think that overall, that's a real asset for the community to have. So for those reasons, I think that the positives outweigh the negatives, and I would be in favor of the application, considering all the conditions that we put onto it.
Yes, sir.
So I don't have as much time in the township as you do, Mr. Chairman, but I first saw that property that I remember when we had an application for a fence.
Right.
About 4 years ago.
At the corner of Pear Street.
Yep. And I remember looking at the property, and it was not what I would consider an asset to the community. I'm just reminding people of what has been there in the past. I think the conditions we've come up with are with the conditions. I think this is a positive thing for the community.
Thank you. Mr. Goldberg.
Yeah, I concur with my fellow board members. I mean, I've been to the property. The treatment of the property, it's stellar. I mean, they've done a great job of rehabilitating it. It's certainly an asset to the community. People I meet around town have been there. They love it. It's really it's all good news. I think with the restrictions we put on them, with the things we've stipulated to for them to agree to tonight, on balance, makes for a good approved application. And I can only see more great things happening at the space, and hope to be fortunate, should this pass in this form, to maybe attend an event there at some point down the road, or have an event there for my own family. So nothing but good things to say to the addition to the community. When we sit up here as sort of volunteers on the zoning board, we have to take into account the totality of the residents of the residential area. The attorney, what's the attorney's name?
Rosenbach.
Mr. Rosenbach, thank you. His points aren't lost on me about the master plan and, really trying to restrict commercial development in a residential neighborhood. So taking that all into account, though, based on what we've put forward here today, it would be in favor of approving it.
So I'm in favor of approving this. I've been out to the site on several occasions. I'm very, I've looked at it for this particular purpose, and I've also shopped there with my wife. So it's a very nice place to go. I think the people of Morris Township will be very happy with the approval, and I look forward to you to go in there, maybe some events at point in my future. So that's it.
Anything else to add, Mr. Williams?
No, nothing.
Yeah, I just wanted to add, concur with what the other board members have said. But I want to add that one of the items in the master plan was the maintenance of existing commercial area. And this had been a commercial area. And it was a very depressed commercial area. And this applicant has rejuvenated that area. And with the conditions that we put in place, especially the restriction on amplified music outside, I think that the positive criteria outweigh the negative criteria, so I would be in favor of this application. So having made a motion prior, I think we could have a roll call on the motion.
Mr. Goldberg,
Yes.
Mr. Trachtenberg,
Yes.
Mr. Williams,
Yes.
Mr. Schuster,
Yes.
Mr. Benoit,
Yes.
Mr. Kramer,
Yes.
Mr. Woodford.
Yes.
Motion
Okay,
carries.
I will have a resolution for you a month after you get me the transcript.
Yeah, later on, April 15th still, I think, and then this one shortly.
Yeah.
So we'll get you that ready.
Okay,
Some light reading for you.
yes. It's going to be a fun
Thank you very
one.
much. We'll keep
Thank you.
enjoying the
Okay.
process. Good seeing everybody.
Only person who's probably been in this town.
Anything else, Mr. Chairman?
Is Betty.
Oh, yeah?
Yeah. Yeah, she graduated from Morris.
Mr. Chairman?
I think
Motion to adjourn.
Oh, motion to adjourn.
Motion to adjourn.
All in favor? Aye. Meeting's adjourned.